so that he can hear. And if there's something he needs to say, then he'll be on the phone.
Mr. Burdette, can you hear me? Can you hear me
I can
now?
hear you. Can you hear me, Judge?
Yes, I can. And I see Mr. Nordby. Can you say something, Mr. Nordby?
Yes, Judge.
Okay. And Ms. Bouchard, are you one of the lawyers in the case?
Judge, I am the stenographer for the
Okay.
hearing.
All right, great.
Oh.
Okay, I see Ms. Maddox, Mr. Barron. Just Mr. Barron, I just unmuted you. Can you hear me?
I can, Judge.
Okay, is Mr. Bardos, he's one of the lawyers?
He is,
Yes,
Your Honor.
All right, I can't, let me see. Let me try to find his thing on here. Looking for Mr. Bardos. There he is. I don't think he has any audio now at all. There's no indication. Hello?
Your Honor, this is Andy Bardos. I can hear you fine.
Okay, great. All right. So as I understand, the lawyers we have are Mr. Kitchen, Mr. Burdette, give me a minute. Your name will come to me. Hold on. Give me a second. I've been reading papers all weekend, so. All right, sorry, Mr. Nordby. Mr. Nordby, Mr. Barron, Mr. Bardos, and we have the staff attorney here. So I think, is that everyone who's has a speaking role?
Your Honor, this is John Boudet. That's all on our side that would have a speaking role would be myself and Mr. Bardos may also speak. Also joining us on the call are our co-counsel, Bruce Braun and Chad Schaefer, but they will not need to be.
Okay, I can unmute him if you want me to. Let me just, Mr. Braun, I'm
Sure.
going to unmute you just in case. And Mr. Schaefer, I'm going to unmute you. All right. All right. And Mr. Nordby, you can hear me still?
And Judge, and I'll be the only person speaking, planning to speak for the department.
Okay, so let me just double check all my settings here. All right. Let me just check one other thing. All right. So we have multiple motions today. Let me get my legal pad out. I think we have motions by Department of Economic Opportunity to dismiss, motions by Beloit to dismiss, and I think there's also a motion to strike by Beloit. And then there are responses by the plaintiff, and this goes to the second amended complaint. I've read everything at least once, some items more than once. There's a lot of material to digest, so we'll see how I'm doing once we get through the arguments. So I guess the first one in my book here is the DEO's motion to dismiss count 1 and 2. So Mr. Nordby, let me just tab counts 1 and 2 in the complaint.
Judge, it's counts 1 and 3. Those were the two counts that
I'm
were.
sorry, 1 and 3. You're right, it's 1 and 3. All right, this is 1. That's the negligence count. And 3, that's breach of fiduciary duty. By the way, I found a case. I guess this is maybe, you all knew this already. I had a feeling that breach of fiduciary duty was in fact a tort. I found the Florida Supreme Court case that said breach of fiduciary duty is a common law tort. Let me see if I can, yeah, well, I found LeBlanc versus Acevedo, 258 Southern 3rd, 555, 5th DCA 2018. It says breach of fiduciary duty is a tort, and I'm pretty sure they cited to a Florida Supreme Court case. And I think that's Gracie versus Eker, EA. KER 837, Southern 2nd 342. Let me find that. That's here. Yeah, it's right here. Gracie versus Eker says, find it. The Florida Supreme Court opinion. It defines the elements. It's in here somewhere, but I believe that it's clear from the case law I've seen that breach of fiduciary duty is a common law tort. Is there any disagreement on that?
No disagreement from the department, Judge.
How about from the
None
plaintiff?
none from Deloitte.
Disagreement on that?
None from Deloitte, Your Honor.
Oh, hold, Marie, I don't, wait a second. For some reason, Marie, you're muted. Okay, Ms. Maddox?
No, sir, the LeBlanc case was actually our case. And so,
That was your case.
yes.
Let's see. Well, I see that, Marie Maddox and Gaultier Kitchen. Well,
Yes, sir.
congratulations on that. Well, wait a second. And you won on that case.
We did. We certainly did.
Okay. All right. So, so 1 is negligence, 3 is breach of fiduciary duty. I think we're all agreed that those are both common law torts. So,
Well, Judge, let me just say one thing. The reason that we've argued that because they derive from a statute. And I think the court's right based on the LeBlanc case and the arguments that we made in LeBlanc, it would be at least the breach of fiduciary duty. Yes, sir.
okay. So the reason I ask you that is I don't know whether when Mr. Norby's getting into a 768-28 argument, but 768-28 is for the record, is the waiver of sovereign immunity, which was passed by the Florida legislature sometime in the 1970s. There had been some cases that talked about waiver of sovereign immunity, but I don't think it was ever codified by the legislature as to the scope of that until that time. And that's why when we say 768-28, we're talking about the waiver of sovereign immunity under the circumstances set forth in that statute. And as I recall, that statute, it explicitly let me pull up the site on that, 768-28. Well, let's see, statutes.
And Judge, if the argument's going to be whether the 180 days applies, because we have given the statutory notice, 180 days is not up yet.
Okay,
And we would acknowledge that. What I tried to argue on the negligence claim was it was by statute, it's a statutory tort. And I've looked at that, and it may be closer to a common law tort, but the basis of the duty is by statute. And that would be the same thing with the breach of fiduciary duty.
okay,
Duty derives from the statute, but it's still a common law negligence claim.
right. Well, that's what I think. I finally found the statutes here. Torts. And the more I read, the more I realized this is a multifaceted issues of law. And I'm not very good at doing anything multitasking. So I just want to lay out waiver of sovereign immunity, waive sovereign immunity for torts, but only to the extent specified by this act. Actions at law against the state or any of its agencies to recover damages and tort for money damages appear to be what's covered in the statute. So I'm going to have to take some notes. Negligence and breach of fiduciary duty or common law torts. All right, Mr. Nordby, sorry. But, let me ask a question. I know I think there was one other case. It's not really a companion case, but the mandamus case, Ms. Maddox, that you and Mr. Kitchen handled, is that case still ongoing, or what's the status of that case?
No, sir, we did not pursue an appeal on the denial of the mandamus.
Okay, so no appeal on the mandamus. So that case effectively is over.
It is.
Okay, man. All right. This case. Okay.
I don't know whether, just as a technical thing, I don't know whether Mr. Barron is muted by his own muting or whether that's by the court's muting.
Oh, I would never mute Mr. Barron. There you go, Mr. Barron. Thanks, Ms. Maddox. Okay. I
was going to say,
Go ahead.
I'll self-mute myself anyway, though, whenever somebody else is talking, just so you don't hear any background noise.
Yeah, I don't know if you self-mute yourself, whether you can unmute yourself.
I don't think you can.
Okay, never mind, then I won't self-mute
So
myself.
the lawyers probably ought to stay, unless you have like some unusual background noise or something, I think you're all fine. Excuse me. All right, so Mr. Norby, what portion of your argument would you like to start on?
Judge, as you always do, I know you've read everything, so I wanted to start by presenting our motion to dismiss the second amended complaint, just the highlights of each of our different aspects, respond to some of the arguments that has been raised in response by the plaintiffs, but most importantly, answer, Judge, any questions that you have about the arguments that we've set out. We're here today on the department's motion to dismiss the second amended complaint. For purposes of the motion to dismiss, of course, the department accepts all of the plaintiff's well-pled allegations as true. Our motion raises 5 independent grounds, any one of which would be a sufficient basis to dismiss the second amended complaint. I'll say at the outset, though, that DEO continues to make progress in processing and paying claims for reemployment assistance under both state and federal law. At the time of the injunction hearing, DEO had paid about $2.7 billion to claimants since March 15th. As of today, just 3 weeks later, the total payments to claimants were just over $7 billion in just 3 weeks. The job isn't finished yet, but DEO's efforts have made substantial progress, and they will continue. The legal question before the court today, however, is whether the plaintiff's second amended complaint is legally sufficient to state a cause of action against the department for the common law torts of negligence or breach of fiduciary duty. Those are the only two claims asserted by the plaintiffs against the department, and both should be dismissed as a matter of law. The first legal basis on which the court should dismiss the second amended complaint is actually the same reason that the court denied the plaintiff's motion for preliminary injunction. The relief sought in the second amended complaint is inconsistent with the separation of powers provisions of the Florida Constitution. The plaintiffs are asking the court to impose tort liability based upon planning level decisions of the executive branch regarding the design of the reemployment assistance system and the decisions made by the department regarding how best to respond to an unprecedented increase in first-time claims for reemployment assistance.
Let me stop you there, Mr. Nord, because I have some questions there for you. Excuse me, I'm going to get a throat lozenge. I'll be right back. Okay, let me get this. Sorry for the coughing. It's I have no other symptoms. All right. Reading this is I have read all of these cases that are cited by the parties here many times over the years. Some of them it's been a while since I read, so it gave me a chance to make a little construct in my head about them. But in the separation of powers issues, is that entirely consistent with the planning discretion analysis in Trianon and the other cases, or do they overlap with some differences?
I think the latter. I think they overlap but have some differences. There are some similarities in the two different defenses that we've raised in our motion. But under both of them, a straight separation of powers argument and a sovereign immunity argument, the courts have said that it is improper for the judiciary to impose liability based upon discretionary or planning level decisions. I think sovereign immunity reaches principles outside of the Trianon framework, but it's consistent generally with the same sorts of concerns.
Okay, so here seems like there's 4 areas that you've raised. Let me see if I have them down. Maybe this might not. Okay, something just fell in my office, but I don't know what it is. Methods of handling. All right, so this is kind of my own way. You have one issue is the purchase of the original system from Deloitte. It's what I call it, purchase of the original system. Secondly, maintenance of that system. That brings up what I call the IG reports allegations. Third are whether or not to upgrade that system. Fourth, what I call methods of handling the claims. I'm going to just call it claims emergency. So it seems to me that whether you call it planning or separation of powers, the case law is pretty clear that the initial system, the upgrades and methods of handling are considered either planning or separation of powers issues. Do you agree or disagree with that analysis?
Judge, I'd agree with that. I think the discretionary or planning level decisions go beyond those, but I would agree that those decisions clearly fall within that category.
Now, going back to my favorite example, the traffic light, I now realize that if you read some of these cases, not all examples are created equal, in the sense that there are different levels of governmental function that are involved in some of these cases. I think the traffic light derives from is it the commercial carrier case? It was not a traffic light, but it was a road marking. And if I can give the analogy with the traffic light, the initial determination would be we have an intersection. Let's put a traffic light there. And it's going to have one traffic light with red, green, and yellow. That's clearly a planning decision. That's what I call whether or not you should have a computer system, who to buy it from. In this case, who do you buy the traffic light from, who manufactures it, etc. Then the issue is, well, this intersection's gotten so busy that maybe we should have 3 traffic lights instead of 1 traffic light. And I believe that the case law is pretty clear on that decision, whether to or not to upgrade is also a planning decision, which is immune from liability. However, if the bulb in the light burns out, it seems, at least with traffic lights, that's a maintenance operational system for which there can be liability. So what's your thought on that?
Judge, my thought on that is that to extend the analogy, what we have here is not really akin to a situation of a bulb going out in a traffic light. What we have here is more akin to a traffic light that was functioning for a road that had fairly limited capacity of traffic, and all of a sudden the roads are all jammed up with cars. So the sort of decisions that we're looking at here aren't like going out and putting a new bulb in the traffic light. Believe me, if that was all that was necessary to fix this system, that would have been done. The sort of decisions that we're pointing to that are continue to be in the planning level and discretionary are things like, in the traffic light analogy, do we send flaggers out to redirect the traffic? Do we put a policeman out there with a sign or a flag? Do we detour the traffic onto other roads? Do we try to widen the roads or let people drive onto the shoulders in a way to try to relieve the traffic situation? I think factually that is the sort of situation we have here as compared to a bulb going out. And those sorts of decisions are just ripe with the same sort of discretion and planning level decisions that you had at the earlier stages that you mentioned.
Yes, I agree in part there. All right, here we go. One issue, and I don't think I can necessarily handle this on a motion to dismiss, is the plaintiff, I think, alleges that there's some maintenance that was recommended by the IG that was not done by the department. The issue is, and I don't know whether that's can be resolved on a motion to dismiss or not, were those maintenance items that were not done, did they result in any inability of the system to work as properly designed? That's the bulb goes out in a light example. So I'm going to place that over to the side. The other issue is the methods of handling what I call the claims emergency or the influx of claims. And I had the case pulled here. And let's see if I can put my hands on it. Here it is. Wong versus City of Miami. You may recall that I mentioned that case earlier. And it is a Florida Supreme Court case, 1970. And it predates 768-28, Trianon Park, and some of the other cases. And it deals with allocation of law enforcement forces. So I do recognize that the analogy might not be directly a one-to-one because it depends upon the type of government function you're looking at. For the record, Wong is W-O-N-G, and that is versus City of Miami, 237 Southern 2nd 132. And this dates back to when I was a senior in high school. In 1968, there were disorders in Miami Beach that was the host of the Republican National Convention at the time. This was in August, and you may recall that there had been civil unrest at the Chicago Democratic Convention that same year. And merchants in the area where there was going to be some demonstrations requested increased police protection because they were concerned that they might suffer property damage if things got out of control. And so numerous police officers were stationed in the area. And then later, as the evening wore on, according to the court, these officers were ordered removed by the mayor and confirmed by the sheriff of the county. And as the court in its understated manner stated, some of the participants in the rally lost restraint, and resulting in some damage to those stores in the area in excess of $100,000, which back in 1968 was a lot of money, still is now. The plaintiffs, the store owners, sued for damages on the theory that the removal of the officers was a careless and negligent act, since they knew or should have known that damage to the petitioner interest would result. And this became a duty in what I'd say a separation of powers issue, a duty and a methods of handling an emergency issue. The city argued that police protection was a duty owed to the public generally, which would not inure to the benefit of particular private victims or citizens. It's an unusual legal concept that's still debated in various cases, but it's clearly the law under certain circumstances in Florida. The city also argued that removal of the officers was within the realm of government discretion. The theory, I think, was that removal of the police would actually result in less aggravation of the people in the area as opposed to having their presence there. That was what was given at the time. The Supreme Court said that inherent in the exercise of, in this case, police powers is the right to determine strategy and tactics for deployment of those powers. And I'll come back to that in a minute, because that goes to my methods of handling claims emergency issue. And it says the sovereign authorities ought to be left free to exercise their discretion and choose the tactics deemed appropriate without worry over possible allegations of negligence. And they distinguish some other cases that talk about duty owed to individuals as opposed to the population as a whole. And the petitioners, the plaintiffs in that case, cited Hargrove versus Town of Cocoa Beach. In other cases, and the court said that those cases did not apply. So basically what the court in Wong versus City of Miami, which I think is still good law, but it was early sovereign immunity law, is that when it comes to allocating governmental resources, particularly police resources, so long as it's a legitimate attempt to do that as opposed to a refusal to provide police protection at all, that's a method of handling an emergency that's discretionary, and it's a separation of powers issue in a sovereign immunity. They didn't use the term planning then, but it's really a planning discretionary issue. So what are your thoughts on that? Because you've raised this issue of the methods of handling this particular claims emergency.
Judge, I agree that the methods of responding to the emergency are something that is discretionary and planning level for the reasons that you outlined in that case. If I could, I'd like to take a second to see if I can convince you that you can also resolve the IG report issues on a motion to dismiss, because we assume the truth of the allegations there. But the decisions by the department of how and in what order to respond to any particular Inspector General report finding are also decisions that are laden with policy making and discretionary decision making. Does finding one get handled before finding two? Does the legislature need to appropriate money to the department before it can even address that issue? All of those sorts of decisions in prioritizing and funding and implementing responses to an Inspector General finding are all the sort of things that involve discretion by the executive branch in the same way, or at least a similar way, to its choice of how to respond to a particular emergency situation.
Okay, I'm just making some notes.
Because Judge, I don't think that even the plaintiffs have suggested that the department's failure to address an Inspector General finding standing alone is a sufficient basis to impose tort liability on the Department of Economic Opportunity. I don't think that's a claim that they've made. It's certainly not a claim I've seen supported by any of the precedent that they've cited. So all of the sorts of decisions that the department made in setting up a system for reemployment assistance and responding to this particular circumstance involve a great deal of discretion in exactly how it's going to be addressed. And for that reason, we think they're barred under separation of powers principles for the same reasons as in Citizens for Strong Schools. It involves a lot of discretionary decisions regarding education policy, or the Dawes case that we've cited involves a lot of discretionary decisions by FWC regarding deer hunting licenses. Separation of powers, even beyond the specific cases of sovereign immunity, would bar claims that would attempt to interject the judiciary into imposing liability or directing specific discretionary decisions of the executive branch.
So is your argument that, at least in part, that in impugning or allowing for liability based on the IG report necessarily involves a court deciding that there are certain things the IG recommended that they should have done first versus other things? For example, the IG recommends that they not use social security numbers from a computer security standpoint, but I don't know that, I have not seen a connection between that and the system not working.
That's right, Judge. I don't think that they've made any connection between some of the findings and what they've actually alleged are the concerns here, second amended complaint. But even beyond that, even for something that may connect in some way to the claims that are being made in the second amended complaint, for a court to impose tort liability based on the department's decision to take one action as opposed to another in this process would involve the judiciary second-guessing discretionary decisions that are committed to the executive branch and to the legislative branch to the extent that they implicate any funding.
All right, so I don't know if this is a proper place in your argument, but I wanted to ask you about this issue of whether there's a duty or not. Is that in a different place in your argument, or do you want
Judge,
to?
That's the next place in my argument, but it may make more sense to address any questions you have about the pure standalone separation of powers argument. I want to be sure that I address any concerns that you have on that before moving on.
So I think I understand it. I've always, to be honest with you, in my head in the past, I've always kind of just morphed those into the planning discretionary analysis, although I have seen some cases, when going back and reading the cases, they do distinguish between those two arguments, but they seem to be very similar.
Yeah, I'd agree. I think there's a lot of overlap, Judge. The Citizens for Strong Schools decision, for example, both at the first DCA level and at the Supreme Court, was not really decided as a duty or a sovereign immunity type of case. It was decided on justiciability grounds, going to subject matter jurisdiction. The Corcoran versus Geffen decision, the first one of the two that came out from the first DCA, also, I think that one granted a writ of prohibition, and it said that where a complaint seeks relief that would violate the separation of powers provision, the trial court lacks jurisdiction to consider it. So that case also framed the inquiry in terms of subject matter jurisdiction rather than sovereign immunity per se. But I agree with your observation that there is a lot of overlap in the two defenses. I think there are also cases saying sovereign immunity is derived from separation of powers. So maybe sovereign immunity is one subset of the broader concept.
Okay. If your argument then is that if I determine that the complaint asks for completely for matters that involve that could run afoul of the separation of powers argument, then I don't actually get to sovereign immunity because there's no jurisdiction.
I think that's right. I think either one of those two arguments could be a basis for finding that there is no jurisdiction. Either sovereign immunity, more specifically, or separation of powers more broadly, under the precedent that we've cited, would say that the court lacks jurisdiction to consider those claims when a complaint seeks relief that would violate the separation of powers provision.
Okay.
And I think Corcoran versus Geffen is probably our leading case for that principle.
Corcoran, let me just make
Judge, that was
Corcoran v. Geffen.
Corcoran versus Geffen from the first DCA. There were two appeals out of the same underlying action. The one I'm referring to is the prohibition case. So plaintiffs alleged that the legislature had not appropriated funds to a donor matching funds program, and the trial court denied a motion to dismiss. A writ of prohibition was sought from the first DCA, and as to that count, the first DCA granted the writ of prohibition and said that where a complaint seeks relief that would violate the separation of powers provision, quote, the trial court lacks jurisdiction to consider it. Now, it denied the writ of prohibition as to some of the other counts and sent it back down.
Give me a second here. Let me look at that case. Corcoran, that's tab 12 here. I'm just trying to think. I don't think that was the case I was on, was I? I don't recall that case.
Judge, I believe that was one of your esteemed colleagues. I don't believe you were on that one.
Okay. All right. I'll take another look at that again. All right. I think I understand where you are on those issues. If you want, are you finished with that, or do you want to go over to the whether there's a duty owed to the plaintiffs in this case?
I'm happy to go on to that argument, Judge. So in addition to being barred by the separation of powers provision, the second amended complaint does not allege facts sufficient to support its legal claims against the department for negligence or breach of fiduciary duty, the two common law torts that are alleged against the department. The threshold question, of course, every first-year law student learns, the threshold legal question in any tort action is whether the defendant owed the plaintiff the duty of care. As a matter of law, the department does not owe the plaintiffs here a duty of care enforceable in a tort action with regard to the claims in the second amended complaint. We've cited the Manfrey case, M-A-N-F-R-E, for the principle that duty of care is a question of law to be determined by the court, assuming the truth of the facts in the complaint. As to negligence, we've cited the Trianon Park case, which, Judge, you already mentioned, which stands for the principle that a government entity's discretionary functions don't create a duty of care. We've also cited cases for the fact that legislative enactments for the benefit of the general public also do not create an independent duty of care to either individual citizens or a class of citizens. As to the negligence claim, the second amended complaint does not allege any common law duty of care regarding the administration and availability of Florida's reemployment assistance program or the Connect system. The program is inherently governmental in nature, so there's no analogous duty of care owed by a private individual that could form the basis for a duty of care here. Nothing in Chapter 443 of the Florida statutes creates a duty of care enforceable in tort for the benefit of individual members of the public or any private right of action against the state. We cited the Florida Supreme Court's decision from 1994, Murphy versus N. Sinha Company, that says statutes that do not purport to establish civil liability, but merely make provision to secure safety or welfare of the public as an entity will not be construed to establish civil liability. Now,
Can you give me that name again, Mr. Norby, of that case?
I can. Judge, it's Murthy, M-U-R-T-H-Y. The citation is 644 Southern 2nd 983. Florida
Okay.
Supreme Court, 1994.
All right.
Judge,
Thank you.
I
Go
want
ahead.
to be careful. I want to be careful to be clear that Chapter 443 certainly provides administrative remedies for individuals that the plaintiffs in this case have not satisfied, have not exhausted. But the availability of administrative remedies to challenge decision making by a state agency does not impose a duty of care or civil liability enforceable in tort in circuit courts. Finally, the second amended complaint's negligence claim is legally insufficient because the duty imposed by the law of negligence, even assuming a duty, does not extend to economic interests in the absence of bodily injury or property damages. So for those reasons, the negligence count fails to establish a duty of care and thus at the threshold stage does not state a cause of action against the department for negligence. The analysis as to breach of fiduciary duty is very similar, so I won't belabor the point. The second amended complaint does not contain any legally sufficient allegations establishing that DEO has a fiduciary or confidential relationship with the plaintiffs where a duty is imposed, a special duty is imposed on the department to look after the interests of the individual plaintiffs. A claim for breach of fiduciary duty requires the existence of an actual fiduciary relationship. The statutes establishing the reemployment assistance program here make clear that the department acts in an administrative capacity in evaluating and paying reemployment assistance benefits, not in a fiduciary capacity. The second amended complaint does not identify any statutes establishing a fiduciary relationship between the individual plaintiffs and the department with respect to the evaluation and payment of reemployment assistance. Nothing in the common law establishes a fiduciary agreement between the department and the individual's plaintiffs under these circumstances either. So without a duty for either negligence or breach of fiduciary duty, both of those claims fail at the threshold stage of pleading.
Can I go back to the argument about law of negligence does not include a duty to protect purely economic interest, and you cite Monroe versus Sarasota County case. Is that an economic loss rule case?
I believe that it is, Judge.
So let me ask you about that. Now, we're really going to get into the weeds when we start talking about economic loss rule. As I understand the 2013 Florida Supreme Court case, I'm told that this was a question that judges who would come before the Judicial Nominating Committee would get asked from time to time, although I was not in that process, so I'll say that is judicial rumors. Did they understand the economic loss rule? And the Florida Supreme Court, as I understand, in essence, rescinded every case involving the economic loss rule except those cases as it relied that pertain to products liability claims. So what's your thought on that? As it relates to, there is a line of cases that I understand it that would support your argument, but it seems to me the Supreme Court has rejected those in 2013. I can't recall the case, but it's cited in the motion filed by Deloitte.
Judge, let me, I think that the Tierra condominium case may be the one that you're referring to. Let me look at the case if I could have just a moment.
I think you're right. It's 2013 Florida Supreme Court. I'll go to it also.
It is the Tiara case though, Judge.
Yeah, tab 83 in this notebook, if everybody has the same notebook, let's see. It's a Tiara condominium. It's 110 Southern 3rd, 399. And the Supreme Court said there was a question posed. We answer this question in the negative and hold that the application of the economic loss rule is limited to products liability cases. Therefore, we recede from prior case law to the extent that is inconsistent with this holding. And it says that here's how it seems to me would have applied in this case, but for the Tiara case. In keynote 1, it says, simply put, the economic loss rule is a judicially created doctrine that sets forth circumstances under which a tort action is prohibited if the only damages are economic losses. Here in this case, although there's been pain and suffering damages alleged, I don't see anything in the complaint that allows the plaintiffs to recover pain and suffering damages because they've not alleged an impact. So it looks like it's purely an economic loss case, but I'm not sure the economic loss rule applies to this case anymore.
And Judge, that I think you mentioned, we mentioned that that Monroe case just in a line or two in our motion. I believe Deloitte made it more of the focus of their motions. That may be something that be more appropriately directed to them at the appropriate time.
Okay.
We think the duty analysis that I went through is a sufficient basis without even going into the economic loss rule justification.
Yeah, on the duty, I understand the concept. I know the plaintiff has alleged this in a complaint and placing someone in a zone of risk. And there's several cases, and a lot of those deal with what I call custody or restraint cases. You're stopped on the side of the road for a traffic ticket, and you're restrained, and the law enforcement officer says, stand here, and then you get hit by a truck because you were standing too close to the road. Or someone who is put under protective supervision. I think there's a case involving someone who's put under protective supervision, and then that person gets attacked by the person they were supposed to be protected from. And another one I think is involving where law enforcement has a prisoner and they let him work on a work detail and he injures another party. Those are all duty cases. It seems to me that the concept of duty has been expanded in those cases a little bit because the person who was injured was not under restraint. These cases first started, as I understand, where a person's freedom of movement or to locate or position themselves was controlled by someone other than themselves. Therefore, that person who controlled them had placed them in a zone of risk and had a responsibility to ensure their safety. Like a child taken into custody by Department of Children and Families and placed in a foster home might be an example. The cases involving, I think one of them happened in Tallahassee, a prisoner escaping a work detail and injuring someone in a mall parking lot. That person who was injured was not, their movement was not controlled, but there was a duty given in that case. And that's why these cases are not completely intuitive, to me at least, in the sense that they seem to be factually driven also. So the argument here is, tell me if I'm wrong, from the department standpoint, is the statute requires us to do certain things. We owe that to everybody, but from a standpoint of tort law, we don't have a special duty to particular people, but to everyone. So therefore, the department's not amenable to tort law. Is that right, Mr. Dorby? Is that what you're saying?
That's right. That's right, Judge.
I do understand that for those who are not lawyers, and perhaps even lawyers may find that a hard to understand concept. But my job is not to tell the appellate courts what the law is. It's their job to tell me what the law is. So I'm just trying to understand the arguments here. And tort law and contracts law are primarily intuitive, but not all the time. So do you have anything else that can help me as why, for example, in the commercial carrier case, if the stop sign marker is placed wrong and someone drives through there, there's liability. So how is that different from this case where there's no duty based on your contention?
A couple of reasons, Judge. I think and it may go back a bit to the argument that we were just talking about with the level of decision making. The decision here to set up a system and the decision of the legislature to put the department in charge of the system by itself does not establish tort liability for the manner in which it's implemented. Now, the department has an obligation to make payment, and there are administrative remedies that are put in place if the department does not make payment in the amount that an individual claimant believes that they are entitled to receive. But that's an entirely different legal construct than imposing tort liability for the manner in which the department has carried out its responsibilities under the statute. That's where the tort concept of duty doesn't transfer over into the allegations here in the same way that this is not a case of someone who was put on the side of the road, told that they couldn't move from the shoulder, and then a car hits them. In that case, someone is put directly physically into a location of risk. In this case, if someone was told to stand inside a computer server that was managing this program and they got electrocuted, that might be a situation where tort liability would come into play with the duty of foreseeable risk, but not in the circumstance here where a general statute is set up for the protection of the general public and the department is in an administrative capacity rather than any kind of fiduciary or special trust relationship.
Let me ask you this question. It's a little bit off topic, but this occurred to me while I was reading the paperwork, and I'll ask the plaintiffs if they wish to respond to it. They can also. But assuming there are, I've heard figures in the last hearing, 50 to 400,000 people who may have claims if there's a class. As I read Chapter 768-28, there's a limit on the amount of aggregate damages that can be awarded for the same acts of $300,000. So I understand that perhaps an argument will be made these are separate acts. I don't know, but an argument also could be made these are the same acts, but just different damages. So does that, if that's true, if the limit of damages is $300,000, then that would let you give about 300 people $1,000, if that's the case, without having a claims bill of the legislature. Of course, you can have a claims bill at any time the legislature decides it wants to pass a claims bill. So do you have any thought on that one way or the other?
Judge, it's not an issue that we've briefed at the motion to dismiss stage. I think it's something that if the case does move forward, would certainly be briefed. We don't think you need to get to there because we think the second amended complaint should be dismissed. I would mention, though, that with the $7 billion of claims that have already been paid to some 1.4 million claimants, the average claimant to this point has received close to $5,000 in benefits over the last 3 months since March 15th. So to the extent any tort recovery would be much further limited than that, I think it's a valid concern that you raised.
All right. Do you have, I'm looking through here, Mr. Norby, do you have any other issues that you want to discuss? Let's talk about pre-suit notice. I found a case. Let me see if I can get to the series of cases. You know, I've said several times, clearly have the authority to stay if there's a failure to comply with 768-28 pre-suit requirements. And I still think that there are cases out there that explicitly say that. I don't know that I've found them, but I did find Allen versus Cruz. I don't recall if this was cited by either side. First district case, 2014. 136 Southern 3rd, 758. And the Department of Corrections was sued in that case. And it's a pretty recent case. And the trial court dismissed the claim against Secretary of DOC, I think because of the failure to comply with 768-28. And the first district reversed and pointed out that the law requires notice to be filed with the Department of Financial Services within 3 years, and that the notice provision is strictly construed. And they said the trial court found that the appellant, that would be the plaintiff, did not comply with the notice requirement because he failed to present his claim in writing to DFS before filing the lawsuit. And then they say, but prior, and they italicized prior, notice has not been strictly required. The fact that appellant apparently gave notice after the filing of the complaint was not an incurable defect, as the 4th District has noted. And then the 4th District says notice is a temporary procedural bar to a lawsuit against the state. The court permitted the amendment of a complaint to allege compliance with 768-28 where notice to the governmental agencies were given after the filing of the lawsuit. And there's some other cases that kind of dance around that. I still think I haven't found the cases that I remember from through the years, but I think that case stands for the proposition that that was a case where I don't even think they alleged compliance with pre-suit notice. I think that was alleged here. If pre-suit notice has not been complied with, but could be complied with, then it seems like the court has authority to either A, dismiss and without prejudice and let you amend, or stay. And I believe there are cases out there that say that. That's been my clear understanding for many years. But there's also another 1st District case, 1989, 548 Southern 2nd, 877, that reversed the judge for dismissing the complaint at a motion to dismiss based on this, and said that the court acted prematurely in considering matters that should be properly raised as affirmative defenses. And it says the function of basically they said it had been alleged and that's enough. So here I have kind of a hybrid. It's been alleged, but I don't think anyone disputes that the 76828 notice requirements have yet been completely complied with. I think from everything I know about this case, they can be. So what is your suggestion of what would be the proper way to handle that in this case, Mr. Norby?
Sure, Judge. On the last point that you raised, I think that if it is apparent on the face of the complaint that the pre-suit notice requirements could not have been complied with, as I think everyone stipulates is factually true here, I think it is appropriate to consider that on a motion to dismiss in a way that it wouldn't be if you had to go beyond the face of the complaint and make additional fact finding. So I think you can get to that question here because on the face of the complaint, it's apparent that 6 months have not elapsed. So it would be impossible to say that the 6 months had run. On the broader point, we've cited a few cases, starting with the commercial carrier case from 1979 that I know Your Honor is familiar with. In that case, the court said that the Florida Supreme Court said that compliance is a condition precedent, so the complaint should be dismissed without prejudice. I think the case that you've cited, and I don't have that one in front of me, I don't think the plaintiffs had cited it. I think it's correct if what it is saying is that failure to comply with a condition precedent isn't an absolute bar to them ever being able to make the action, to make their claim. I think what the appropriate remedy is for a dismissal without prejudice, and then once they have complied with the condition precedent, they have the ability to reassert their complaint. We cited three additional cases in our reply brief that I think go to this. The Bellina case, Bellina case from the 5th DCA in 2017, I think is an instructive one. In that case, the 5th DCA actually granted a writ of certiorari quashing a trial court order that had abated the action on the grounds that the case should have been dismissed without prejudice when there was
Tell
a
me the name of
pre-suit.
that case. Tell me the name of that case again.
The one of the parties' names is Bellina, Bellina.
International event. That was not a 768. That was not a 76828 notice case, though, was it?
It was a different pre-suit notice case, but the pre-suit notice principles, I think, apply there as they do in 76828. I think one of the other cases we cited, maybe been the Scullett case from the 2nd DCA, was a 76828 case. And then the HCA versus Lindbergh case from the Florida Supreme Court as well. What they seem to say, without drawing specifically from the construct of 76828, but more generally as pre-suit notices, is that the remedy for failure to comply with the condition precedent that can be met at some point is to dismiss without prejudice and allow the claim to be made after the condition precedent has been satisfied. We think that would be the appropriate remedy here.
I think that could be done, but I think the trial court also has the authority to use the stay mechanism instead of a dismissal mechanism. And what makes this kind of there's a couple of scenarios we could have here. I could deny your motion completely and that of Deloitte completely, and then stay the case until the notice was complied with. Or I could grant the motions in part with leave to amend, and then what do we do with the stay? Say you don't have to amend until the time runs, or what? And then the other scenario is that I grant some motions completely, which would ordinarily give a party a right for an interlocutory appeal. And should I stay at that point? So it's again, it's not as simple as it usually is, because whatever I rule on the sovereign immunity issue, I would think one side or the other may very well appeal. I think that's probably, well, if I rule 100% in favor of the state on sovereign immunity, that's clearly an appealable order from the plaintiff's standpoint. If I deny at least a part of what the state is saying, then I think that's still an appealable order, because the sovereign immunity issues are appealable interlocutory orders. And that still leaves, the computer company there, which is, I mean, a separate situation. So do you have any further thoughts on that?
Judge,
I haven't decided what to do about that.
Judge, I would just commend to your attention the Skullock versus D case that we cited. That was a second DCA case from 2014, citing commercial carrier. In that case, there's a statement that that the party in that case did not allege compliance with condition precedent in 76828. And the court said, while this would properly subject his suit to dismissal with leave to amend, the circuit court dismissed it with prejudice. This was error. We think that that's the process that should be followed here. A dismissal without prejudice, dismissal with leave to amend after the condition precedent has been satisfied.
Well, if I did that on 76828, then I wouldn't need to have to rule on any of the other issues that have been raised. Right? Couldn't I just defer ruling on those?
Judge, we have alleged these as independent grounds for dismissal of the complaint. That's right.
Well,
And
I guess the easy way would be for me to not address the tough questions, but you know, I don't
Join the meeting.
I don't know that. Oops. When did that? How did that happen? Let me see. Okay. All right. So,
and Judge, and I'm certainly not going to argue that that you should rule in my client's favor on one ground as opposed to another. I think any of them would provide a basis for dismissal. So I would want to discourage you from any of them. I think each of the 5 grounds that we've argued, separation of powers, duty, sovereign immunity, failure to exhaust administrative remedies, and the pre-suit notice all provide a basis for dismissal. Now, some provide a basis for dismissal with prejudice, perhaps, and some without prejudice, but all provide a basis for dismissal rather than moving forward.
so let me ask you on, let's set 76828 aside. Let's just put that over into a different area. Do you contend that your grounds are, I believe you contend your grounds are all with prejudice grounds, that they can't be amended. It would be futile to amend the complaint?
Yes, Judge.
Okay. All right. So here's what I want to do. I want to give the plaintiffs unrestricted time to respond, but I want to give the court reporter a break and everybody else a break. So can we come back in at 3 o'clock? And then
You
I'll
can,
turn it
Judge.
over to the plaintiffs. Yes, sir.
And we're happy to stand on our papers on the sovereign immunity argument. We haven't talked specifically about that, but I want to be sure that Your Honor knows that is a separate and independent ground on which we're saying the case should be dismissed.
All right. I want to ask the plaintiffs to discuss this issue. I think damages, pain and suffering damages, I just don't think that there's an allegation that supports that. There's no impact. And there's a bunch of cases on that. I have one here somewhere, but there's no impact alleged. And I don't think you can recover damages for negligence without an impact.
And Judge, I can talk about that.
Okay, I'm gonna let you, let's do that. Let's take a break and come back at 3, okay? I'm just gonna leave my computer on and I'll be back in about 10 minutes. So I won't start without anyone. So, okay, we're on a short recess.
Tammy Menke joined the meeting.
Thank you, Merle. Period. I will tell her. I said hello. Okay. Mm.
Okay, I'm back. All right, let's see. I think I see everyone there. So who wants to start for the point? I want to give the plaintiffs time, and then we need to reserve at least the last hour for the Deloitte motion. So who would like to go? Okay, Ms. Maddox. Are you deleted? Wait a second. Oops, let me unmute you. Let's see.
There we go.
Okay, I think I've got everybody. I think I got Mr. Nordby unmuted. Okay, Mr. Braun. And Mr. Kitchen, I think. Okay, all right, I'm ready.
Okay. Judge, let me start with the easy arguments. Okay, the first one is that the Tierra Condo case only dealt with products liability. And what the cases in Florida have said is that the impact rule only serves to limit emotional distress damages and does not serve to negate plaintiff's damage claim for compensatory damages. And that is the Latson versus Hartford Insurance case. It is a middle district.
I agree with you. I think that impact rule does not limit your request for economic damages.
Yes, sir. And there's also, there are a couple of cases from the Florida Supreme Court that also talk about, and it's not been pled, and we would request a leave to be able to plead. And one is the Zell versus Meek case, 665 Southern 2nd, 1048. And the other is Champion versus Gray, and that is 478 Southern 2nd, 17. And what the court said there is that no impact need be shown where psychological trauma could be demonstrated to cause a discernible physical injury. And in this case, although it's not been pled, the discernible physical injury, we have some folks that I know have discernible physical injuries because they were not able to get their medications. And
Those cases aren't, Ms. Maddox, aren't those cases limited primarily to intentional infliction of emotional distress cases, defamation cases, and the very unusual cases where you may see a family member or a child injured in your presence, something like that?
No, sir, they haven't been. As a matter of fact, what the courts have said more recently, this is the first DCA in 2007. And
Okay.
What they've said is the rule has developed such that it is now satisfied by the physical manifestation of emotional distress.
Do you have that site, Ms. Maddox, the DCA one, the first DCA?
Yes, and the first DCA is 948 Southern 2nd, 976. And what the court said in the Brady versus Funeral Services of Florida, Inc. case, the impact rule does not apply to conduct that is alleged to be willful and wanton. And then you've got the Champion versus Gray case, where it talked about the discernible physical injury when such injury is caused by a psychic trauma. Zell versus Meek. And there are others, and I could provide the sites to the court in those I have actually gotten past motions to dismiss in cases. One was in front of Judge Frank just recently, where I'm sorry, it wasn't in front of Judge Frank, it was in front of Judge Duncan, where it was in a school setting. And the case was Zoe Fiorazanti. And in that case, it was also a negligence case. And we got past a motion to dismiss on that issue, on the issue of whether we had to show physical impact. And we were able to show that there was a physical manifestation of an emotional injury.
Okay, hold on a second. I had a case here. Just a second here. Let me see if I can find what I'm thinking about. If not, we'll go on. Give me a second here. That's not it. That's not it. Okay, that's fine, Ms. Maddox. I've taken your sites down. I want to look at those too.
Okay. All right, Judge, the next issue that I think would be pretty simple is the whether the court has to dismiss or whether the court can abate or stay the claim. And we have cited cases on page 31 of our response in opposition to the DEO motion.
Hold on, let me find that. I have that here. Plaintiff's memo, okay, page 30.
31.
I've got, okay.
And in Burgess versus Lipman, fourth DCA case in 2006, the court held that the proper remedy for premature litigation is an abatement or stay of the claim for the period necessary for its maturation under the law. And
I knew I wasn't imagining things where I had read that.
yes, sir. And we have cited that, and also have cited a couple of other cases for that proposition.
Okay, let me make a note. Abate. Let me make a note. Abate see plaintiff's reply memo. I have read that page, but for some reason I missed that case. Memo page 31. Okay, thank you.
And Judge, let me just go to a bigger issue I think that the court needs to address and perhaps have DEO address. They've argued for the case to be either dismissed or abated, whatever the court decides, but they can't really have it both ways. They're arguing also for the dismissal. So it's either going to be abated or it's going to be dismissed. If it's dismissed, which is what they're arguing, and they need to choose, are they arguing for dismissal? Because if they're arguing for that, I think that the proper route would be the abatement and then abate it and then come back and consider all of these issues. So
Yeah.
I think they've got to make a decision. What are they arguing and what position are they taking? So that's number one. With that in mind, let me go to the substance of their argument on the sovereign immunity, the separation of powers. And what the case is actually saying on the separation of powers is that the court cannot tell. And
Ms. Mannix, could I ask Mr. Norby one question on that point you raised? Mr. Norby, if I simply deferred ruling on the sovereign immunity issues and abated the case, would that give you a right to appeal the first DCA under their cases on sovereign immunity?
Judge, I don't know the answer to that question. Any order that is issued that raised sovereign immunity should be an appealable order on an interlocutory basis, but that's not an issue that we briefed. So I'd want to look at that on the direct question that Ms. Maddox just posed. We did address in our reply that we believe the correct result is a dismissal without prejudice or dismissal with leave to amend. But certainly it seems like at a minimum, abatement would be appropriate here rather than proceeding.
Okay, thanks. Thank you, Ms. Maddox. You can continue.
Your Honor, on the issue of the separation of powers first, I don't think that argument even applies here, because the issue that has been raised in the cases that they have cited have been injunction cases. And the case that counsel said was his primary case that he would rely on, and that's the Cochran versus Geffen case. That was, again, an injunction case. So I don't think separation of powers is the issue at all. I think that the issue is going to be the dichotomy between discretionary versus operational functions. So the Cochran case was an injunction case, and the court found that it had no authority to entertain an injunction. However, and what counsel for DEO did not mention was that the breach of contract claim in the Cochran case, the court found was a proper claim to have been brought. And if we are granted leave to amend, which at the end of the day, I'm going to ask the court if we can have leave to amend, because I'd like to come back and flesh out the issues of the emotional injury, the physical manifestations of the emotional injury, because we do have plaintiffs that fit in that category, as I've said, that I'd like to consider. We could maybe even bring a breach of contract claim. There could be one. So anyway, that was not prohibited by the separation of powers. But what the cases say that they have cited, and this is in their memo, that the judiciary violates the doctrine of separation of powers if it directs an administrative agency to perform its duty in a particular manner or in a manner that is not feasible. And the problem with their argument is that's not the issue in this case. Okay, we're not asking the court to direct that they perform their duties in a particular manner, okay, or in a manner that's not feasible. And by the way, that issue as to whether it's feasible or not feasible would not be properly resolved on a motion to dismiss in any event. That would be a matter for summary judgment, but not, because whether it's feasible or not, the court can't tell from the four corners of the complaint whether it would be feasible or not. What we do know, and I think the court hit the nail on the head when, Your Honor, you went through and looked at the different categories and whether it's discretionary versus operational, and the purchase of the original system, we have argued that that is, in fact, a planning decision. I think the court is probably right that it's a discretionary decision. The maintenance of the system, though, that has been our argument from the very beginning. There are statutes that require, and I can go through those, and they've been cited ad nauseum through all of our pleadings, but they start on page 18 of our memo. And it starts with 443.031. And what the law says is that this chapter shall be liberally construed to accomplish its purpose to promote employment security by increasing opportunities for reemployment and to provide through the accumulation of reserves, which is the trust fund that I'll talk about later under 443.191, for payment of compensation to individuals with respect to their unemployment. Now, the defendant has argued that this is the public at large, okay, that we're claiming that this is a statute just that protects the public at large, but that's not true. And what we have pled is that there's a specific class of people who worked in the state of Florida but became unemployed due primarily to COVID. And there are cases that talk about that is a sufficiently defined class rather than being to the public at large. And by the way, I wanted to go back and just divert for 1 minute because, Your Honor, you raised the issue of the sign, and how isn't that to the public at large? Anybody who's driving on that road, could be subject to the sign falling down. The question is, and what we've raised and briefed in our memo on page 11, starting on page 11, is the foreseeability of risk. And what the courts have said is that where a defendant's conduct creates a foreseeable zone of risk, the law generally will recognize a duty placed upon the defendant either to lessen the risk or see that sufficient precautions are taken to protect others from the harm the risk poses. So when you look at foreseeability and you look at the risk that is created by the defendant's actions in this case, by not properly maintaining the system so that people can file their claims and you get a prompt adjudication, okay? The greater, as the court said, in Kaiser versus Cole, and in a ton of other cases, Henderson versus Bowden, Florida Supreme Court, the McCain case, what they've said is the greater the foreseeability of risk, the greater the duty. So here, the public at large would not be the protected group, okay? The public at large, or the group that would be protected would be the folks that are applying for unemployment. And that is a specific class of people who worked in the state of Florida, but because of unemployment due primarily to COVID, were not able to process their claims sufficiently. There's a case that we've cited on page 14 of our memo, and it's First American Title Insurance Company of St. Lucie County versus Dixon. And in that case, the clerk of the court had failed to properly index a notice of claim of interest on certain real property. And there was a statute that required that the clerk take certain actions. And what the court said there is the clerk conceded that he had a statutory duty under section 28.222 Florida statutes to properly record and index documents in the public records. That duty flowed to a specific class, i.e., those claiming an interest in land, including bona fide purchasers of property and creditors of property. So when you look at a statutory duty, which is essentially what the defendant is arguing, that there can't be a duty owed to the general public. As the court said in Dixon, it's to anyone who claimed an interest in land, including bona fide purchasers of property and creditors of property. Here, we have exactly the same thing. We have folks that are seeking unemployment compensation benefits. So it is no different, it's indistinguishable from Dixon. And the same is true in the estate of Brown versus Woodham. And in that case, and even though Your Honor may have mentioned it a minute ago, there was a statutory duty to protect victims of domestic violence. And in this case, and that was the statute upon which the court relied. I know because I represented the woman who that was there at the home, the estate of Brown, and he ended up killing Woodham at her residence. And so the issue was whether the domestic violence statute would have protected someone else who was in the home with her at the time that they had failed to keep Woodham, or not Woodham, but failed to keep Mr. Strova incarcerated. And so the court again looked at the special duty exception referenced in both Everton and the restatement. The court referenced 741.2902 and stated that it was the responsibility of the trial court in considering the release of an offender to consider the safety of any person who might be endangered by the release. Again, looking at special duty. So the statute may not have protected Mr. Brown, the estate of Robbie Brown, Mr. Brown from being killed. What the court found was that there was a duty owed under that domestic violence statute. And so did it get owed to the public at large? No, it was only owed to people who were the victims of domestic violence. So that again, the estate of Brown versus Woodham would be indistinguishable from this case, because you've got a group of people again who are the intended recipients of those benefits under the law. So I don't know how they can get around the arguments and the Brown, the Dixon case, and other cases that are cited in our memorandum and are referenced in both the Brown and Dixon case, because you've got a specific group of people that are, it's not just John Doe, that's working around the corner at First Federal Bank who's not unemployed. That would be the public at large. These people are unemployed. They're unemployed people who are seeking the benefits that the statute allows them to have. So let me go back to the duty issue, okay, and what the law says. Okay, and because the defendant has argued that this is, and they have no duty essentially, because you've got a discretionary function versus operational. And I want to go to maintenance of the system. And I quoted a minute ago 443.031, which is what the legislative intent is. But let me move to 443.091. And that is the statute that says that an unemployed individual is eligible to receive benefits for any week only if the Department of Economic Opportunity finds that A, she or he has made a claim for benefits for that week in accordance with the rules adopted by the department. That is where the rubber meets the road. You take that statute 443.091, which imposes a duty on DEO to determine, to have a system where they can apply for these benefits, who has made a claim for benefits for that week, and make a determination as to whether they're eligible to receive benefits. So then you move to 443.1513B, and DEO is required to promptly provide an initial monetary determination to the claimant. And there's a statutory duty that they have to act within 20 days. So I don't know how they can claim that they don't have any obligation under the statute that it's discretionary, because inside 3B, it says monetary determination. In addition to the notice of claim, the department shall also promptly provide an initial monetary determination to the claimant. And then it goes on to say, the monetary determination must include a statement of whether and in what amount the claimant is entitled to benefits, and in the event of a denial, must state the reason for the denial. But what we have here is, when not only do we not have a prompt determination of the eligibility for a benefit, but we also have an entire group, 50,000 plus people that we're estimating, that they have no reason stated for the denial, which means that they are prohibited from taking an appeal. You have to have a reason in the denial in order for them to even have an appeal. These aren't discretionary words. It doesn't say may, you can do it. It says must. They are required under the law to maintain the system. So let me go back to this discretionary issue. And I want to just cite to the court, and I'm going to read only part of it because it's in our brief. It's on page 2. And it's the Department of HRS versus Whaley, Florida Supreme Court, 1991. HRS nevertheless argues that the caseworkers were exercising discretion in handling the reported child abuse, and that their actions were planning level activity under commercial carrier. This argument is grounded on the definitional approach to discretion, which we rejected, because all government functions, no matter how seemingly ministerial, can be characterized as embracing the exercise of some discretion in the manner of their performance. We have no doubt that the HRS caseworkers exercise discretion in the dictionary or English sense of the word. But discretion in the commercial carrier sense refers to discretion at the policymaking or planning level. We agree with the district court that the actions of caseworkers investigating, responding to reports of child abuse simply cannot be elevated to the level of policymaking or planning. Then it goes on to say, operational level acts, therefore, are not necessary to or inherent in policy or planning, but rather reflect only secondary decisions for implementing discretionary plans and policies. The court need go no further than the Florida Supreme Court decision in Whaley to understand that the defendant's argument, the DEO's argument in this case, is just plain wrong. There were planning decisions, we'll concede. There were planning decisions that were made at the upper level as to who was going to be selected to maintain the system. But thereafter, when you have a statutory requirement that you shall do X, Y, and Z, and they have not done it, which is not even questioned in this case, they can't come back before the court and say, Judge, we complied. We did everything we're supposed to do. They didn't. And I'll tell you that we have thousands and thousands of people who will come before the court and tell them that they didn't. So when you look at that, of course, they're going to have some discretion. And what DEO is arguing is that, well, we do have discretion in how do we do this or how do we do that. They don't have discretion under the statute as to whether how somebody can apply for unemployment claims, and that they must make a determination within a certain time period. They haven't done that. And, you know, Your Honor raised the issue of the audits. And the audits are a big deal in this case because the audits, and we may not have properly pled that the all of the 600 findings in the 2017 audit or 2019 audit, I think it may have been 17 or 19, that they directly impacted the operation of the system. Well, I can come back and I can do that. There were 600 findings saying that it didn't do this, you have not done this, you have not done that. So the question is, in light of that evidence, in light of the fact that you've got the audits by the Attorney General or by the Auditor General's office saying that you have failed to do this, warning them about a system that is going to fail in the event of a pandemic or another, you know, catastrophe, huge event like hurricanes, that they did nothing in spite of even that notice. So they've had time after time after time. There have been 3 audits that have come in and told them that they needed to change this, this, and this. And you know what their response was? We'll look into it. Their only response has been, we'll look into it, year after year after year. So what happens then is that leaves us up to now. And what happens is you have a state that is in a dire sense of an emergency, and you have people that are the most impacted by the COVID, meaning they're unemployed, that can't access a system that's supposed to work on their behalf, the protected group. And as a matter of fact, Mr. Barron is going to address this issue in a minute on his argument on Deloitte. But if you look at the contract, and I think the contract has been filed, or at least he cited the contract, the intended beneficiaries under this contract were the people in Florida who were going to be applying for benefits. It was recognized in the original contract between Deloitte and the state of Florida. So they can't get around the intended beneficiaries of this contract between Deloitte and the state of Florida. So, Judge, I have cited a number of cases that that show that this is in fact not a discretionary duty, and that it is an operational function where they are supposed to keep the system operating. And again, as the Whaley court said, there's going to be some discretion involved every time that that a worker does anything with the government, but it's not the kind of discretion that commercial carrier was referring to. And when commercial carrier talked about the discretion, it was looking at the policy level functioning, not what they're actually doing on a day-to-day basis to make the system work or not make the system work. These are people that are sitting there working. They're not the secretary of the department that's sitting there making a decision about whether somebody can process a claim or not. These are workers like me, okay, that are out there me and others, okay, that are out there trying to get the benefits. So, and there's no policy making involved at all in that. Judge, I don't know what other issues they have. One of the cases that we've cited also, or one of the things that we talked about in our brief on page 5, is the 4th category, where it's almost in the claim of like a malpractice. And that in rendering specific medical services, DEO has committed malpractice, a breach of its duty in rendering the specific unemployment benefit services for which the government is clearly liable in tort. And, you know, going back to the separation of powers issue, if you buy their argument, okay, then why do we have lawsuits, okay, that would allow citizens in the state of Florida to sue the government for not doing their job. Okay? If you go with them and look at what they're arguing, essentially, you would have no lawsuits at all because you couldn't challenge anything that the government did under a separation of powers. And that's not that. You see cases every day. Your Honor presides over cases every day where negligence is the issue. So some of these issues I think may be ripe for summary judgment, okay, and to go through it in summary judgment, but not on a motion to dismiss. Not when we have pled that there was a duty and we have set forth the statutory duty. We have pled breach of that duty and that we have pled damages. And I acknowledge that there are going to be different categories of folks that, we've set out 10 different categories when we did our last hearing. And I understand the court's ruling. We're not challenging the court's ruling on the injunction. We don't plan on appealing that. I understand why the court ruled the way that you do and looking at the separation of powers issues, but that's not this case, okay? That is not, we're not bringing the injunction again. We're not bringing a mandamus. We're asking the court to let this case go the normal case as normal cases would do to be able to do discovery, to find, there may be other bases of liability. But as long as we agree that it's a legal issue for the court to determine, is there a duty? And we have set forth a number of statutes that show where the statutory duty is by DEO, and they shouldn't be able to wiggle around those by saying, well, this was discretion.
Okay, you even got the court reporter choked up on that one, Ms. Maddox. Hold on, let her take a drink of water. Okay.
Thank you.
All right. Anytime you want a break, just give me a sign and I'll be glad to take a break too.
Let me look and see if I have left anything out. Let me talk a minute about breach of fiduciary duty. The statute is 443.191. And if the court looks at that statute, it is, and what it says is that the Florida statutes, the state of Florida and the federal government have created an unemployment compensation trust fund through which funds collected under Chapter 443 are collected and deposited to pay unemployment compensation benefits. That is the sole source of money from which the unemployment compensation benefits would be paid. And breach of fiduciary duty. Fiduciary is trust, breach of the trust. And that money was designated, and they're making the first quarter, and I think I said this during the last hearing, the first quarter, we've gotten the documents, and they made $25 million in the first quarter of this year, okay, just on that trust fund to be able to pay out the money to the unemployed. And we believe that because the trust fund is the sole source, that they have breached their fiduciary duty to the citizens of Florida by refusing to pay that money out and refusing to pay the most needy now in the state of Florida, those folks that are still unemployed. And by the way, the system ain't fixed, okay? It still has problems. We're still getting calls literally daily of the system and people that are not getting their money for one reason or another. I did send one of them to Mr. Norby, and I believe that he's been paid as a result of me sending it to him. But there are thousands of others like it. I can't forward every single email that I get to Mr. Norby and ask him to please look into this one personally.
Well, as many as you can, I'm sure he would have somebody look into them. You're not the only one getting messages.
I'm certain, Judge, yes. But we have claimed here in the lawsuit that DEO had a fiduciary duty to maintain the trust fund for the benefit of the unemployed. And by failing to pay those monies out in a timely basis, that breached the trust and breached the fiduciary duty that DEO had to the citizens in Florida who were trying to get their unemployment claims. And Your Honor, I know that Mr. Kitchen cannot participate verbally. And I don't know whether he can say yes or no, whether he has something that he needs to say.
I think he's agreeing with what you're saying.
No, right now. Okay,
Yeah.
got it.
He's saying Maddox, yes, the other side, no. Let me ask you this question, Ms. Maddox. The breach of fiduciary duty is interesting to me. And I take it, as I understand your argument, is that the statute itself is the basis for establishing the breach of fiduciary duty.
It is, Your Honor.
I do not know of, and I'm asking, are there cases in which an appellate court has held that a statute creates a fiduciary duty with a very broad class of people? Do y'all have any cases that you cited on that?
I have not cited any on that, and I don't know whether Mr. Barron can address that issue when he addresses the Deloitte issue. I did want to make two other points, though. One is on the cap, the 200,000, 300,000 cap.
Yes.
It would be 200 per person, and our argument is going to be that the $200,000 cap applies per person because they're each separate and independent. And as I said before, it's not just one thing, okay? It's not just one thing that's happened wrong. There are 10 that we've been able to come up with. There may end up being others, but each person, in our opinion, has a separate independent claim, which would have a separate $200,000 cap.
Well, if you had a car with 6 people in it and they got hit by a state truck, wouldn't the limit of damages be 300,000 for that group of people?
It would, but the problem here is that you don't have, that it may end up being that you've got 10 different classes of people or more that all had different things happen to them because there's not one individual thing that happened. And so you've got,
I have not made my mind up on that. I'm just suggesting that that's an area, that's a field that may never have been plowed before, that specific legal issue.
yes,
If there are cases out there that discuss that on a case like this, I'm not aware of those. So I'll give you a second.
okay, Mr. Kitchen does need to say something. He just told me that, so I'm gonna put him on speakerphone to talk in just a minute. So,
Okay. All right. Well, thank you. I'll go to whoever is next to speak for the plaintiff.
okay.
Judge, if I may, this is Gautier Kitchen, and I'm so sorry about all the feedback.
I'm sorry, Judge. I
The court
can't,
reporter is not able to get it. Let's try it again. You're getting a lot of feedback.
Let me try this out of camera.
Okay.
Can you hear me now?
Let me ask the court reporter, can you hear him?
yeah,
Take it down? Okay. Go
Judge,
ahead.
And I'll speak at the very end after Deloitte has made their presentation. I just wanted to say, insofar as fiduciary duty, it's notable that these funds, not just state funds that are premiums held by the state or state allocated money, but also federal money earmarked for the Florida unemployment system, are held in trust. The most basic thing we know about any trust funds, whether it be my firm or any other way we earmark funds as held in trust, implies almost states definitely are held in trust. On the flip side, on the note of the cap, as far as class action goes, the alternative would be for 50,000 people to file individually for negligence, etc. Our contention is that the cap, and I'm sorry that I thought it was $200,000. I may be incorrect in that. Your Honor said $300,000, but that applies per plaintiff, not per a class. And I will leave it at that. Ms. Maddox has done a tremendous job arguing this. I just wanted to point out funds held in trust implies a fiduciary duty, not to mention the statute. And secondly, that the cap would be per plaintiff.
So, okay, let me ask you this, Ms. Maddox. your argument, if it's accepted by the court, would have pretty big consequences, because what that would mean would be the United States government would be in a fiduciary duty with every single Social Security recipient. The state of Florida would be in a fiduciary duty with every Medicaid recipient. They'd be in a fiduciary duty with every teacher, state worker, retiree. Now, fiduciary duty is a unique concept. So I'm not saying I agree or disagree. I'm just saying that's a big issue.
It is. And Judge, I don't know whether those statutes actually say what the trust fund statute says here under 443.191. And what it says is the funds are collected and deposited specifically to pay unemployment compensation benefits. As I understand the Social Security rules, those funds are coming from, and I may be completely off on this, but I thought that they were coming from a general revenue fund. That
Well, there's
would
a
not
social-
be specifically.
There's a social, I mean, this is again getting in the weeds a little bit, but this shows the implication of the argument. There's a Social Security trust fund, which is, in theory at least, made up of funds paid by Social Security taxes by employers and employees. However, it's well known that the federal government has borrowed money from the Social Security Trust Fund for many years and replaced them with IOUs or bonds. So the question is, if there's a fiduciary duty and the fund becomes underfunded, does that create a class action lawsuit for 300 million people?
Judge, absolutely it could. Okay, I don't know that, but I know here in this case that where they have not paid the money out as they're required to pay it under the law, that yes, in this case, because I don't know what could be created, because the question is payment, and with Social Security, they're continuing to pay that money. Here,
Well, if you get a Social Security case, Ms. Maddox, will you please file that in federal court?
Yes, sir, I will.
Okay, all right. All right, so who's next on, anyone else for the plaintiff on this? Because I want to go to the Deloitte motion. Mr. Norby, do you want 5 minutes to reply before we go to Deloitte?
Judge, this is Scott Barron. Can I just add something with regard to the arguments that were just made?
Yes, Mr. Barron.
It'll take away, I mean, it's going to be something else that I was going to address on the Deloitte arguments, but I think it ties in also with what Ms. Maddox and Mr. Kitchen were arguing, which was, if you look at, and we cited to it in our brief, but if you look at page 10 of the contract, again, this contract between Deloitte and
Hold
the
on,
state.
time out. That contract's not attached to the complaint, is it?
It was filed with the court.
I know that, but it's about that thick, right?
Well,
And it's not attached to the complaint. On a motion to dismiss, can I take into account matters that are not attached to the complaint?
Well, I think it was a notice of filing of exhibit to the second amended complaint, and we filed the.
Oh, you filed it as an exhibit to the complaint?
Deloitte complained that Deloitte didn't even raise in their motion to dismiss that the complaint was not attached, and I agree the rule requires that a written contract be attached to a complaint if you're suing upon it. So
Okay,
then
the plaintiff attached it. The plaintiff attached it.
We
Yes,
did.
sir.
There's a notice of
Okay,
filing.
that's different.
Yes.
I can take that into account.
Yes, notice of filing of second amended complaint. And yes, it is 123 pages with 17 amendments. They were all filed with the court. But note what
Were
I
they
think,
single spaced?
yes, actually, most of it is single spaced.
That's what I thought. And it was filed at the end of last week, wasn't
It was, Judge.
it? Okay.
Yes.
Let's just make sure we're all on the same page. All right.
But what I think is notable, I mean, without going through, and obviously I haven't even gone through every provision of this entire contract and every amendment yet. But if you look at on page 10, section 2, there's a section called problem statement. And what the state said in this particular contract with Deloitte was, the agency impacts the lives of Florida citizens at a moment when their needs are greatest. AWI operates a $6.5 billion unemployment compensation program that is responsible for processing 3 million claims, applications, and making payments to 1.1 million individuals per year. The unemployed citizens of Florida use these payments to provide the bare necessities for their families while they look for new employment. And then it goes on to talk about basically, in the balance of this problem statement, what the intentions were of the state unemployment system when they contracted with Deloitte, what they were looking to do, which was basically, create a more efficient, automated system, less labor intensive, et cetera. But what I think is helpful about this problem statement is it shows that, the very intent of this entire arrangement of them updating the system, the claims processing system, the creation of the Connect system, all of it was intended to benefit the discernible class of the unemployed of Florida. And as the state of Florida said, at a time when these people need these payments to provide the bare necessities for their families while they look for new employment. So.
Okay, but as I read the fiduciary duty statute, I know you're referring to third-party beneficiary law, but the fiduciary duty, a claim for fiduciary duty is only created when both parties agree that it's a fiduciary confidential relationship, right? It's not whatever you agree with Deloitte doesn't present a fiduciary duty between the state and 16 million people, does it? Or does it?
And my understanding of fiduciary duty is my understanding is it doesn't have to be bilateral. My understanding is if one party undertakes the obligation to care for, or look after the requirements of another party, that creates a fiduciary duty. I'm not sure necessarily that it has to be a bilateral agreement.
Well, I could be wrong on that. I thought that it did, but I will take that into account and look at the other cases.
Yeah, I'm just trying to think of it. I can think of examples, I'm sure, where there's fiduciary duties that are assumed that both parties didn't agree to assume, but by virtue of what somebody agreed to do on behalf of the other party, it created a fiduciary relationship.
What's inherent? It's like doctor-patient. It's inherent in the nature of the relationship. Or bank and bank customer is another example of fiduciary duty.
Correct. I don't think you're ever going to find a doctor who said, yes, necessarily, I agreed I have a fiduciary relationship, or a bank that said they have a fiduciary relationship. But I think that, yeah, if somebody who has more knowledge and ability to handle the situation assumes, to take care of something for somebody, and that, I think, yeah, it can create a fiduciary relationship. Regardless,
you do make a good point. We are treading into areas in this case that have never been treaded into before. And that's why I'm not going to rule today. It's unusual for me not to rule at a hearing, but I need to think on this some more. Because the First District Court of Appeal, at least, is going to weigh in on this case one way or the other. And so that's why I want to give it a lot more thought. I want to read everything everyone's written again, read the cases over, and consider my notes on your arguments. So you do make a point. There are fiduciary relationships which aren't reflected by express agreements. And I think Dr. Patient is probably a court-created one, but they do exist, so you're right. Okay, thank you. Mr. Nordby, I'll give you a few minutes.
Judge, I'm going to only try to take 1 minute because I know you have others to hear from as well. I just want to make 2 points in response. The first one is I would agree that the Dixon case from the 4th DCA is the plaintiff's best case on duty, but that case has been described repeatedly as embodying a very narrow holding, including by the 4th District itself.
Is that the title company case?
That is the title company
case. Itself, in a later case, said specifically on that case, this is a very narrow case, and our decision may have been limited based on the fact that the clerk agreed it had a duty.
Judge, you just cited the exact language that I was going to cite. You're familiar with that later holding describing it as narrow, limited to the public records context, and may have been based on the clerk's concessions. So I think that's their best case, and it has been described as an extremely limited holding by that same court. On the subject,
isn't there a first district case involving either a clerk of a court or a state agency, driver's license records, or something where it said there's no duty to maintain accurate records?
there is, Judge, and you're familiar with the body of case law on this, so I just wanted to be sure that didn't go unmentioned.
I'm not saying that I agree with all these cases, by the way. I'm just saying this is what they say.
They do say that, you're right. On the subject of trust funds, this is a new argument that appears to have been developed by the plaintiffs as we're talking today. I just wanted to point out to the court that there are any number of trust funds administered by the state of Florida for any number of purposes where licensure fees or permit fees are deposited into something denominated a trust fund within the state treasury. There is no precedent anywhere, to my knowledge, and I'm fairly certain I'd be aware of it, that fiduciary law applies to the state's treatment of funds in trust funds within the state budget. In fact, it's routine for the state legislature to transfer money from a trust fund to be used for some other purpose in the budgeting process. So the idea that the significant consequences of fiduciary law could be imported into the state legislature's administration of trust funds within the state budget would have dramatic and serious separation of powers consequences that I'd submit on this record are not something that the department would want the court to go near.
Okay, thank you. So let's start with the Deloitte case, and I may well take a break with the court reporter in a few minutes, but let's get started. Is that Mr. Boudet?
Yes, Your Honor. Good morning. Good afternoon.
Good afternoon.
Let me begin by acknowledging the very real frustration and hardship that has been endured by many in Florida. Every citizen in Florida has been impacted by this pandemic, including the thousands of people employed by Deloitte in Florida. There's nobody in Florida that doesn't have a friend or a family member that hasn't been impacted and lost their jobs because of this situation. The motion to dismiss presents this court with a straightforward application of settled law to familiar legal principles. For a bit of background, the state contracted with Deloitte almost 10 years ago to assist with the implementation of a computer program to pay unemployment benefits. Deloitte completed its work more than 5 years ago, more than 5 years before being named in this lawsuit. The system worked satisfactorily through prior surges in claims, through natural disasters, although certainly not perfectly. The system was undisputably not designed for this unprecedented and unforeseeable deluge of claims that came through the pandemic. We understand that this situation has caused tremendous hardship. It's a difficult time for everybody, but this lawsuit is not the appropriate forum to address those frustrations. For a variety of reasons that we've set out in our motion: sovereign immunity, separation of powers, no duty, failure to exhaust administrative remedies. The claims presented are not appropriate for determination by the judicial branch through a class action. Today I'm gonna cover briefly some of the things that Mr. Norby mentioned. I adopt and agree with his arguments with respect to sovereign immunity and separation of powers. The court has previously analogized a few times to the traffic light let me suggest to you another analogy that may be more fitting. This case is really about how many lanes the government decided to put on that road. A 2-lane highway, a 4-lane highway, or a 50-lane highway. Deloitte was the contractor that was hired to build the 2 or 4-lane road. The plaintiff says that this road should have had 50 lanes. It should have been capable of handling, not as Mr. Behrens, you remember he just read to you from the problem statement from the contract. It's interesting that he mentioned that. That problem statement says, we operate this system that handles 1 million claims a year. That was the problem that they had, 1 million claims a year. This court has heard about 1 million claims in a month. So let's turn first to well, let me just add one thing. In denying the motion for injunctive relief, this court recognized that the separation of powers doctrine precludes it from directing the agency about how to grow or improve or augment this system. It's not the business of the judiciary to tell the agency you should have 50 servers or be capable of handling 700 phone calls an hour or whatever it might be. And that exact same doctrine is what prevents the court from looking back, because that's really what the plaintiffs are asking you to do. The injunction motion says, tell them what to do going forward. But the lawsuit has the court second guessing what the department did, how many servers it chose to use in 2014, how many it chose to add, augment, how big, how many. Those are all questions, how much money to spend on them. That's the question that the damages claim is asking this court to go back, to have a jury take a look at what the department did and say, oh, no, that's clearly not enough servers. That's clearly not enough phone lines. So the same reason that deprived this court of jurisdiction to assess improvements going forward is what stops the court from looking backward. Let me start with the failure to exhaust administrative remedies. It was our lead argument, and it is a jurisdictional bar to this action. The plaintiffs in their response do not dispute that they have failed to pursue their administrative remedies. The plaintiffs do not deny that administrative remedies are available to those who have a claim for unemployment benefits that have not been awarded. Rather, in their response, they invoke the doctrine of futility. They say that it would be futile for them to pursue these administrative remedies. The problem is that their complaint, which is the only thing that the court can look to, makes absolutely no allegations that the administrative remedies are futile. In their response, they go into even arguing that there aren't enough referees, that it's going to take too long. None of that's in the complaint. There's not a word in the complaint that would give rise to a futility exception to the rule that a party seeking unemployment benefits must seek first recourse through the administrative remedies. So that is a jurisdictional matter. The court earlier asked the question, should I stay, abate, dismiss on the sovereign immunity question? Both questions touch on the same thing, which is the court's subject matter jurisdiction. It would seem that the appropriate thing for the court to do in this case, in every case, is first to determine whether it has subject matter jurisdiction to proceed. There's no point in staying the case or abating the case if the court hasn't subject matter jurisdiction to begin with. It hasn't even determined whether it has subject matter jurisdiction. It seems logical for the court to make that determination first, and make no mistake that satisfying, exhausting administrative remedies is a jurisdictional threshold, and that plaintiffs have simply failed, and they admit that they haven't pursued those administrative remedies. And that, again, has a separation of powers component to it. By bypassing the legislatively enacted administrative process that puts in the hands of the agency the fact-finding function, the initial requirement to review the actions of its own agency. If the court were to bypass that, it effectively overrides the legislative determination that issue should first and foremost be addressed by the agency. So the ramifications are multiple when you sort of put the cart before the horse, or whatever the phrase is. If there's an order in which these things are done, and this court's jurisdiction cannot be invoked until the administrative remedies have been satisfied and gone through the process. Turning to the specific claims that have been pled. You've heard, I'm going to start with the breach of fiduciary duty claim, which, although all of these claims are, as to Deloitte, are weak, this one stands out. You heard considerable discussion that the fiduciary duty claim was predicated on the management of a trust fund. There's no allegation that Deloitte has anything to do with managing that trust fund, with deciding who gets paid, making individual determinations, or has had any role whatsoever in the administration of that trust fund. Mr. Behrens said that a fiduciary relationship arises sort of in this amorphous, when somebody decides to take care of something for somebody else type analysis. That's not how fiduciary relationships are derived in Florida. We've cited to the cases about how a fiduciary duty is created. It requires one party to repose trust in another, and it requires the other party to accept that trust. Here, the claimants in this lawsuit didn't even exist at the time that Deloitte did its work. These people have not alleged, certainly, that they were unemployed in 2011 and 2013 when Deloitte was doing its work. They actually claim to have been unemployed largely as a result of COVID in 2020, 5 years after Deloitte last worked on this project. When did this fiduciary relationship arise? In February, March, or April, when these people became unemployed? Did it sit there sort of in coate for 5 years, waiting for it to spring to life? It's a theory that simply does not find any facts in this case to support it. That claim for breach of fiduciary duty by Deloitte has no standing. We next turn to the claim for negligence. There's been some confusion about the economic loss rule, the narrowing of the economic loss rule in the products liability setting, and how that relates to the question of duty in a negligence case. The two concepts are similar, but they are not the same. Under general negligence law, before Tierra and after Tierra, under general negligence law, there is no duty to protect another from purely economic harm. Let me just say that again. Under Florida law, the general rule is that there is no duty to protect another from purely economic harm. You asked a couple of questions, including a question of whether the Monroe case was an economic loss doctrine case. It was not. That was not an economic loss doctrine case. That was a duty case. So the question, the threshold question on the negligence claim is whether Deloitte had a duty to protect the plaintiffs from purely economic harm. The answer to that is that it did not. And it did not because Deloitte and these plaintiffs do not fall within the very few narrow exceptions that have been recognized to that general rule. The court is familiar with the body of law dealing with professional negligence, professional malpractice cases that give rise to purely economic negligence claims. The court is aware of the body of law dealing with negligent misrepresentation. There's a body of law that says if a negligent misrepresentation leads to economic loss, it is actionable. But the general rule remains.
Mr.
One case-
Boudet, are we saying the same thing or different things? I call it the impact rule, or do you have a, are we on the?
I think that's a little different.
Same thing? It's different?
No, I think that's a little different. So I'll talk about the impact rule in a moment. This is the question of duty. The threshold question in every negligence case is, did the defendant owe a duty? If the answer to that question is no, you don't go any further.
Mm-hmm.
So the question is, did Deloitte owe a duty to protect against economic harm, which is the thrust of the allegations here. The allegation here is I did not get my benefits and I was harmed. A couple of the plaintiffs have said, I did not get my benefits, i.e. I suffered economic harm, and that led to emotional damage as well. Now this afternoon, Ms. Maddox has introduced a new theory that has not been pled, which is a physical manifestation of that emotional harm. But that's not before the court today. The pure question of law is whether a duty exists on the part of Deloitte to protect the plaintiffs from purely economic harm. And I would ask the court to take a look at the Tetra Tech case, because the court was asking about, after Tierra narrowed the application of the economic loss rule, does that mean that this concept of negligence law not covering purely economic harm, whether that's the same thing? Let's take a look at the Tank Tech case, 244 Southern 3rd, 383. That's a 2018 case from the second DCA. In that case, one company installed underground tanks, and a second company inspected those tanks. And the company that installed the tanks sued the company that inspected the tanks and said, you negligently inspected these tanks and said that the tanks that we installed had all kinds of defects, which we were then forced by the customer to fix. And you were incorrect in your assessment of the safety of our tanks. And it cost us money. And there, the second DCA went through the analysis and explained that that was a claim for purely economic loss, a negligence claim for purely economic loss. And it dismissed that claim on the basis that there was no duty to protect against economic loss. And this is a post-Tierra condominium case. What Tierra did was deal with the separate question of the economic loss doctrine. The economic loss doctrine is a doctrine that deals with the assertion of tort claims between parties that are in contractual privity. If you will, the lawsuit between DEO and Deloitte. If DEO tried to sue Deloitte and raised tort claims rather than contract claims, that's where the economic loss rule would come up. And in Tierra, the Supreme Court said that economic loss rule, which at one time had expanded beyond products to sort of all kinds of contracts, we're going to narrow specifically to the context of products liability. So the negligence claim here fails first and foremost because there was no duty, no common law duty, no statutory duty to protect the plaintiffs from economic harm. To the extent that the negligence claim, which counsel now seems to be suggesting arises from a statutory duty, being a statutory duty owed by DEO, not by Deloitte. Certainly, I don't think they can plausibly argue that that Deloitte owes duties under the contract. But there's no implied private cause of action under that statute. There's no private cause of action, and one cannot be implied. So even if there were statutory duties, even if those statutory duties were enforceable in a lawsuit without exhausting their administrative remedies, and even if those duties applied to DEO, they certainly don't apply to a private contractor. You know, the court raised a question or asked sort of the hypothetical about trust funds and whether the Social Security Trust Fund, everybody would have fiduciary duties, but that broader concept applies to every aspect of this case. In effect, the plaintiff's theory here is that any contractor who supplies a phone system for the Social Security Administration or supplies a computer system or an electrical system, whatever, anything that is ultimately going to be used by the agency to provide services to a consumer or a taxpayer would open any contractor to essentially unlimited liability, in this case, some 10 years after the contract was entered into and 5 years after it was completed, for essentially unlimited economic harms. The courts was right to ask that question and to ponder the ramifications of what this action really would involve. Again, there's been a lot of discussion today about DEO's potential liability on the negligence claim for failing to maintain the system. There's no allegation in the complaint that Deloitte had any role whatsoever in maintaining this system, and certainly nothing in the last 5 years. To the extent that the IG report says that that this or that should be fixed, that's not something that Deloitte was responsible for fixing or had any role in fixing. I think that that's all I need to say on the negligence claim.
Okay.
Let me turn next to the breach of contract claim. Plaintiffs have alleged a claim for breach of the contract between Deloitte and DEO, or its predecessor. First, the claim is barred by the statute of limitations. It is a breach of contract claim on a written contract, must be brought within 5 years of the breach. Unlike tort claims, Your Honor, which accrue when the last element of the cause of action occurs, being damages, claims for breach of contract accrue at the time of breach. There are at least 6 places in the complaint where the plaintiffs allege that this Connect system was defective as of its inception. In fact, they even allege that it was designed to fail. They point to numerous alleged defects from the very beginning. Clearly, there's no suggestion that any of these problems first manifested in the last 5 years. On the face of this complaint, there is undisputed facts establishing that the alleged breach would have occurred no later than 2013, and perhaps as soon as 2011 when it was first designed, but let's give him the benefit of the doubt, no later than 2013. So the claim is barred by the statute of limitations. We raised that in our motion to dismiss. Their response was to cite the court to 3 or 4 cases involving tort claims. There is no case that they have cited involving breach of contract. So the accrual part of the statute of limitations fails. Their backup argument is, well, even if the claim accrued and even if the statute of limitations barred the claim, the court should apply equitable tolling, as the court would do, for example, if a tort has been fraudulently concealed or something. They've cited no case, and we have found no case, where the doctrine of equitable tolling applies to a breach of contract claim. There is certainly no suggestion that Deloitte concealed or otherwise interfered with the plaintiff's ability to assert and have notice of these alleged defects and the alleged breach. Next, the plaintiffs have failed to identify, so even if they could get sort of past those, they have failed to identify any specific provision in the contract that was allegedly breached. Mr. Behrens told you today that there was a problem statement as part of the 142-page contract, but there's no suggestion that sorry, I had a phone call interrupt me, Your Honor. Just one moment.
All right. You can text if you want to. We'll take a break.
I don't want to, but if it's a good time to break, I know the court reporter's been going a while. I'm happy to do so.
Let's come back at 20 till 5.
Very good.
And we'll give everybody a break. I'll see you at 20 till 5.
Thank you.
Okay.
I don't want- Hear me on the phone? Yes? Test 1, 2, 3. My. Battery is dying in my headphones. And yeah, I guess I could do that. You have just a regular, just speaker.
There's the cube. Jacqueline's over there.
Haven't alleged any actual breach of the contract.
How long will I be?
5 minutes. Oh, because I don't charge this thing.
Jack has to sit on this.
Hey, come on in. We're on a break. The meeting Cheetos. I mean, those Cheez-Its. No, no. You're good. Lock me out. Thanks.
Okay, I'm back. We'll let the court reporter get set up.
Let me get back on the record.
Okay.
Okay, Judge.
All right. See. Oh, there we go. Mr. Boudet, I need to unmute.
Yes.
Okay, Ms. Maddox.
Can you hear me, Judge?
Yep. Ms. Maddox, let me get her. Mr. Nordby, I'm going to unmute him. For some reason, it takes a while to do this unmute. I think Mr. Kitchen is, okay, I think we've got everybody. All right, go ahead, Mr. Boudet.
Thank you, Your Honor. I think that I was addressing the plaintiff's failure to identify any specific contractual provision that was breached. Their response to that argument was essentially to say that that's not the law, that we're wrong in arguing that a party who claims breach of contract has to identify the specific contractual provision or provisions that were breached. I don't really think I need to add much more to what we've extensively briefed. It's not a new requirement. It's not a controversial one. The law is well settled in Florida that you have to identify the specific breach to give the defending party notice of what it is that they are alleged to have done wrong. So for all of those reasons, this third-party beneficiary breach of contract claim, time barred, without standing to assert, they're not specific intended third-party beneficiaries. They are the classic incidental beneficiary of a contract and have no standing. And they've identified no claims or no specific contractual provisions that have been violated. That takes care of the breach of contract claim, leaving the plaintiff's two product liability claims.
Are those resolved by Tierra?
They should be. They are resolved by Tierra and by many other cases.
Yeah.
But Tierra left obviously undisturbed the notion of the economic loss rule as a bar to product liability claims involving economic harm.
Mm-hmm.
And so as a threshold matter, the product liability claims, and there were two, Your Honor, a
Right.
strict liability and a negligence one. They didn't even, plaintiffs didn't even respond on the strict liability claim to our motion to dismiss. On the negligence claim, they did respond, but they don't seem to grasp that the economic loss rule is a bar and continues to be a bar on a claim for purely economic harm. The way they responded to that is to say, well, some of our plaintiffs aren't claiming only economic harm. And that is where we run into the impact rule that you asked about earlier.
Mm-hmm.
The impact rule says that you can't seek emotional damages without a physical impact. And so, you know, the sort of the classic example, Your Honor, is sort of the horrible case where someone witnesses a loved one being hit by a car, and the old rule was sort of if you get splattered, then you can bring a claim for your your emotional loss, and that's the simple manifestation of the impact rule. The impact rule remains in Florida very much, and is.
I believe isn't that the Cadillac or the Champion case, something like that?
Yes.
Someone witnessing a loved one being hurt.
Right, and there have been efforts to erode that in cases of intentional infliction of emotional distress. The tort of outrage has been at some points discussed in Florida, but here, just the idea that you can circumvent the economic or the impact rule, literally there isn't a case that comes before the court for money damages where the plaintiff doesn't feel like they should have received money and could claim some emotional upset for not having received it. It would literally be unending. And so that is why the courts recognize the rule. And Ms. Maddox made an oblique reference to she thinks that some of the plaintiffs have physical manifestations. Again, that's not in this complaint, Your Honor. There's no allegation of physical injury whatsoever. And certainly there can be no plausible link between the actions of Deloitte and a physical injury manifested 6 or 7 years after Deloitte last did some tweak on a computer system. Let me finally talk about this we had a motion to strike the punitive damages claims and a motion to strike the attorney's fee claims. No response was made. I presume that plaintiffs have conceded that issue.
Wasn't something that we had talked about even.
Let me just check my notes, Your Honor, and make sure I've touched everything. Oh, sorry, there's one other issue on the products claim. The Connect system is not a product for purposes of products liability law. Products liability law is concerned with tangible objects. It is concerned with things, not ideas. We have cited to you 5 cases that address that issue, finding various ways that computer systems or ideas embedded in websites and those kinds of things are not products for purposes of products liability law. And again, this turns to the attempt by the plaintiffs to put a square peg in a round hole. This case doesn't, against Deloitte, doesn't fit any recognized legally cognizable cause of action. Ms. Maddox asked the court the rhetorical question, well, what are lawsuits for? Well, they're not for this, Your Honor. They are not for the purpose of expanding endlessly with conveying to third parties the ability to enforce contracts to which they are only incidental beneficiaries. They don't exist for the purpose of giving juries and judges the right to second guess an administrative agency about how it allocates funds, how wide it makes the highway, how many lanes it puts on the highway, how much money it spends to upgrade the highway. That's not what lawsuits are for. So we again recognize the tremendous challenges that Floridians have faced. We recognize the frustration of applicants with reaching DEO on the phone, by their computer, all of those things that we have heard about. I don't mean to minimize them in the least, but this lawsuit is not the right place to address those concerns. And with that, Your Honor, I'll wait for any additional rebuttal. Thank you.
Okay, is Mr. Barron, are you responding on this one?
I am, Your Honor.
Okay, you may begin.
Okay. First of all, the analogy that council refers to as the, how many highways were going to be built, whether it's a single lane or 5 lanes. What happened was they were contracted to build a 5-lane highway, and what Deloitte built was a rural dirt road that's inaccessible to motor vehicles. That's pretty much what took place here. So let's clarify that. The other thing is, goes on and on and on about how the the unemployed of Florida are just merely incidental beneficiaries. Judge, all you got to do is read this contract, and in particular the problem statement, where it goes on and on to talk about specifically that this entire contract with Deloitte was entered into to take care of the unemployed citizens of Florida, to provide the bare necessities for their families while they look for new employment. Page 10 and 11 of the contract specifically talks about what the entire intent was of this 123-page 17 amendment contract, which I think dovetails nicely into their arguments about the fact that they're claiming that you have to somehow identify every provision of the contract that was breached by Deloitte, which is not the case law. And I think if you look at the cases they cited, really none of the cases stand for that proposition. Yes, you need to allege a breach. We've alleged a breach. We alleged that they basically did not perform the contract, that they did not set up a system that would satisfy any of the criteria of what was in this contract, including something that could be, people would be able to access if they needed it, something that would provide timely appeals determinations, et cetera. So, but certainly, I'm sure Your Honor, that the pleading requirements in the state of Florida don't require us to go through and identify every provision of a 123-page 17 amendment contract that was breached. They want to ask that in interrogatories, be my guest. They want to, go ahead and get discovery on that issue, be my guest. But that's not the requirements of the very nominal pleading standards in the state of Florida with regard to a breach of contract. Moving on to the arguments that it's funny how, Deloitte's counsel wants to make it seem like, oh yeah, us in the state of Florida, we're all one big team here. We're all one big happy family. No, they're not. They don't get the benefits of sovereign immunity that the state of Florida gets. They don't get the benefits of the notice provisions of 768.28. They are not the state of Florida. They are a third-party company. And so where they go on and talk about how we should get sovereign immunity, make all these sovereign immunity arguments, none of that stuff should be entertained at this particular point in time. In fact, the the very cases cited by counsel on that what we refer to in our response to the motion to dismiss includes the Stoll versus Noel case, the Florida Supreme Court case from 1997 at 694 Southern 2nd 701. And basically that case and every case cited by opposing counsel with regard to whether or not an independent contractor gets sovereign immunity basically says that it's a fact-driven inquiry that's not susceptible really to determination on a summary judgment. In fact, some of the cases say it's not even susceptible to determination on a summary judgment, that it's an intensive fact-driven inquiry. So at this particular case,
I don't know whose phone that was. Okay.
at this particular case where there's been no discovery whatsoever at this point in time or any other documents, no emails, no discovery at all as to what level of control the state did or did not exercise over Deloitte. There's really no way on a motion to dismiss for there to be an argument that somehow they are the agent of the state that is entitled to sovereign immunity, who can share in the full panorama of government immunity. And the cases that we referenced in our response to the motion to dismiss was Agner at 821 Southern 2nd 336, sovereign immunity improperly granted to third-party contractor at the motion to dismiss stage. Sierra 850 Southern 2nd 582, sovereign immunity improperly granted at motion to dismiss stage. There was also Plancher, where they only addressed the issue of sovereign immunity to a contractor at the summary judgment stage. And then we cite to the fourth DCA case of Theodore versus Graham at 733 Southern 2nd 538, where basically it said that even this issue, this is not even something that's susceptible to be determined on a summary judgment because it's so fact intensive. That's a similar type of ruling to the second DCA case of G4S Secure Solutions, where again, they're basically saying this issue can only be determined on summary judgment, where the opposing party can't point to any conflicting facts or inferences whatsoever. So it's sovereign immunity doesn't apply to them. 768.28 doesn't apply to them. They can't even argue that they're entitled to any of that on a motion to dismiss. And it's our position, not even on a summary judgment, certainly not without any discovery, where we can have an opportunity to file opposing affidavits and things of that nature. Then counsel goes on to argue about how, well, we didn't invoke administrative remedies. Well, first of all, it's our contention that the administrative remedies would have been a condition precedent under Florida statutes. A condition precedent under 1.120C of the Florida Rules of Civil Procedure. And as Your Honor, I'm sure is well aware, all we're required to do for conditions precedent is allege general satisfaction of a conditions precedent, which we've done in our complaint. And then the opposing side then has the obligation to deny the satisfaction of the condition precedent with specificity when they're responding to the complaint. Without even getting into and this is not really also the subject of something that can be heard on a motion to dismiss, but as far as even the adequacy of the administrative remedies, I think Ms. Maddox already pretty much addressed with the court that to the extent that the administrative remedies are provided by the state statute, that they weren't adequate, they haven't been adequate, they haven't provided the timely determinations to parties so that they can appeal. In many cases, they've failed to mail out notices so that indicating or advising the parties of their time frames to appeal. We find notices that have been mailed out, they're dated one date and wind up having been received like a month or 2 months later. We have situations where the appeals, you file an appeal, the appeals section of the unemployment never sets it for hearing, which is in violation of state law and in federal law. We have situations where I have some cases where for 3 months now, there's been absolutely no hearing even granted on an appeal that was requested from the state. So, and again, I think all of this stuff, again, Your Honor is well aware what the standard is on a motion to dismiss. It really needs to be based on the four corners of the complaint. And a lot of this stuff, I think that opposing counsel is arguing on both sides really goes well beyond what can be considered on a at the motion to dismiss stage. But administrative remedies is not something either, I believe, that would be available to Deloitte to argue as a defense. Whereas here, it can't be determined at the motion to dismiss stage whether or not they are actually an agent that's entitled to all of the deference that the state of Florida would be entitled to. Moving on next to the the other thing too that I just wanted to note also is, and again, it's been raised multiple times, including at the evidentiary hearing on the injunction, but the fact that again, that Deloitte wants to claim that they're all one big happy family with the state of Florida. I think the state of Florida would probably beg to disagree, because the governor of the state of Florida referred to the system they created as a jalopy, and multiple legislators of the state of Florida have referred to the system that they created as a jalopy. So for them to indicate how, well, basically we created exactly what the state of Florida asked, and it's all great and nobody's complained to us about it, I think is somewhat inaccurate.
So if a member of the legislature says something, I'm just bound by that and I should accept it and go on?
Judge, I think I did preface my comments with there's been a lot of arguments that have been made that I think are outside the four corners of the pleading. And that's one of the reasons why we think that.
Well, you did allege in the complaint jalopy, right?
I think we did allege in the complaint that it was a jalopy.
Right. Okay.
Moving on to the whether or not there is a duty under the negligence claims. And I mean, I think, again, counsel cites to, and we cite to, there's a Florida Supreme Court case called Curd versus Mosaic Fertilizer, 39 Southern 3rd, 1216. And that's probably, I think Your Honor is right, that this particular case deals with factual circumstances that I think we are not going to find in any other case in the state of Florida that's been reported to date, because I think there hasn't been this type of situation before. But I think that the Curd case is certainly analogous, and that it was another situation where negligence was used to, not only did they find there was a duty, but they also found that based upon the pollution that took place, that these particular farmers, that there was not only a duty owed to them, but also that they were entitled to recover solely economic damages in that particular case, because that was their property right, basically was their ability to fish. And I mean, I really think that that's about as analogous of a case as we're going to get to our current situation, which again is very unique. But the Curd case, the Florida Supreme Court indicated that there's 4 different categories of where duties may arise: legislative enactments or administrative regulations, which I think is what Marie Maddox was referring to with regard to the state and their obligations under the Florida unemployment statutes. Judicial interpretations of such enactments or regulations, other judicial precedent, and or a duty arising from the general facts of a case. And the 4th category, and this is what they applied in Curd, is the one where there's a class of cases in which the duty arises because of a foreseeable zone of risk arising from the acts of the defendant. And the Curd case, and they cite, I guess, to the Clay Electric case at 873 Southern 2nd at 1185 cites to the McCain versus Florida Power Corp case that basically says that the statute books in the case law are not required to catalog and express and prescribe every conceivable risk in order for it to give rise to a duty of care. Rather, each defendant who creates a risk is required to exercise prudent foresight whenever others may be injured as a result. The requirement of reasonable general foresight is the core of the duty element. And that's why I think it's so important for Your Honor to take a look. I'm not going to, although I think Your Honor probably would read all 123 pages and 17 amendments to the contract. I'm not asking. I've
done worse than that before.
I'm not asking for you to at this particular point in time, but if all you need to read is that problem statement, because it, in a nutshell, sets out exactly what the state was asking to Deloitte to do with regard to this particular system and what Deloitte failed to do, and why.
I wrote down it's on page 10 and 11 of the contract.
Yes. and
Okay.
why it was so important to the unemployed of Florida to make sure that this system was set up in the proper fashion. So I don't see how Deloitte could possibly ever argue, and I don't see how, I mean, again, I think based upon the four corners of the complaint, and the contract that's been filed, they certainly were put on notice of possible injury to the unemployed in Florida if they do not do their job properly. Certainly it was foreseeable that if the Deloitte did not exercise prudent foresight, that the unemployed of Florida, who are the beneficiaries of this contract, could potentially be injured. I think Ms. Maddox already kind of addressed as far as the emotional distress issues, as far as whether or not the plaintiffs were only seeking purely emotional distress here, and without physical injury. And she talked about all the other types of issues that have taken place, and there were actual damages to people relating to damages to credit, relating to repossessions of vehicles, relating to being forced out onto the street, being evicted in some instances, or living out of their cars. I mean, there's actual damages relating to those types of things. I think, and moving on to the breach of fiduciary duty claims.
Let me ask you, Mr. Barron, is there any case that you're aware of that allows a breach of fiduciary duty to be based upon a statute such as we have here?
Judge, I haven't seen one. I haven't specifically researched that particular area, but I can tell you that the case law cited by both parties, including there's the First National Bank and Trust case from the 4th DCA at 789 Southern 2nd 411, which basically talks about how a fiduciary duty is based on the specific factual circumstances surrounding the transaction and the relationship of the parties. The Capital Bank case at 644 Southern 2nd 515 also talks about it depends upon the specific facts and circumstances surrounding the relationship of the parties. I mean, the case law says that a fiduciary duty can be a very broad concept. I mean, there's a number of cases that say that. So I don't know that necessarily, and I'd have to see if there's anything where it's arisen out of a statute. But in this particular case, at least as Deloitte, I would say that we're not even saying it's solely arisen out of a statute. It's also arisen here out of a contract that they entered into with the state to benefit the third parties, to benefit the unemployed of Florida in a situation such as this one. But it's also, again, it's a fact-driven inquiry. And I just don't think it's something that, based upon the four corners of the complaint, I think there is enough stated there in order to set forth a cause of action for breach of fiduciary duty. Again, it's fact-driven. We're entitled to get discovery, and then they want to argue this stuff at a later point in time on summary judgment, then obviously they would certainly be entitled to do so. With regard to the breach of contract and with regard to the statute of limitations, there's a couple of things I wanted to say on that one. 95.0311 sub 1 provides that a cause of action accrues when the last element constituting the cause of action occurs. And yes, I do agree with counsel that most of the case law in Florida indicates that the cause of action accrues in a case for breach of contract when the breach has taken place. But if you look at the case law as to what the rationale behind it is, that when the breach takes place, there's at least some nominal damages to at least one of the plaintiffs in that particular case. In this particular,
Mr. Barron, you told me that they were contracted to build a 2-lane road and they built a dirt road. So doesn't that result in damages immediately to someone?
Not to these people who are suing here in this particular case.
Well, none of them, I mean, if that's the test, then none of them could have a fiduciary duty because they weren't unemployed at that time. So this fiduciary duty, is it set? How is it determined for all people that work in Florida or all people that are unemployed in Florida?
Well, it's the contract that this relationship was entered into over had to do with the unemployed of the state of Florida. So,
Okay, the unemployed at any time in the future or at that time?
well, it's the contract specifically refers to the future. It's specifically intended to basically fix the outdated system that was already in place and put into place something that was going to go forward. In fact, if you look also at the problem statement in that contract, the contract unemployment goes on to say, across the nation, state unemployment compensation programs are faced with numerous challenges in meeting federal performance standards, while workloads are increasing and state budgets are decreasing. These demands must be met in a highly visible and politically charged backdrop, particularly if employers are faced with tax increases due to high benefit outlays. The UC program in Florida is facing many of these same challenges that face other UC programs nationwide. Some of the key environmental factors affecting the UC program include increased customer expectations, reduced or static funding levels, aging and retiring workforce, and an aging and inflexible 38-year-old existing technology system. The claims and benefits mainframe application is a foundational, mission-critical UC system nearing its end of life. So the whole point of this was we are hiring Deloitte to carry us into the future, to create this system that's going to be able to deal with, our ongoing unemployment claims.
So is there an allegation in the complaint that states what requirement in the bid contract or the contract between Deloitte and the state that that the system did not measure up to in that contract? Is that in the complaint anywhere?
Yeah, actually it is, because if you look at I'm just trying to remember, if you look at our hold on one second, at our opposition brief, there's another provision of the contract. Actually, it was one of the, I think it was the first amendment to the contract that I also cited to. And what it said was, if I can find that in here. Yeah, if you look at Amendment 1 also, Section 11.10, they actually set in the state and Deloitte, I guess, set metrics to, or they call it a section entitled Benefit Realization Key Performance Indicators. And that basically they set out what Deloitte's goals were and enumerated them. And then included reducing correspondence with claimants, making more of the claims electronic, reducing time for adjudication of issues, reducing number of claims that require manual intervention by DEO employees. I mean, if you go through what we've alleged, they haven't satisfied any of these criteria. Reducing manual intervention, every single one of their claims practically these days requires manual intervention. All you got to do is go ahead and, I mean, aside from the people who are named, you could talk to any number of the thousands of people who we represent, and they'll all say that nothing could be done electronically. It's all had to be done manually. They've had to call people. They've had to call people in unemployment in order to try to fix the issue. That's if they can get through to somebody with unemployment. One of the other metrics was fixing the appeals and overpayment process. Obviously, they didn't fix any appeals process because none of the appeals are being processed at this point in time. People aren't even getting determinations as to the appeals.
Is there anything in the contract documents, and I'm relying, I haven't looked at them yet, but I will, that state how many calls this is, how many unemployment applications at any one time that this was designed to handle?
That I can't tell you, Judge, off the top of my head, honestly. I mean, I still haven't had an opportunity to go through all 123 pages and 17 amendments, but I'm sure other than just the Amendment 1, which sets out all the guidelines, the performance criteria that they were supposed to perform, and, the problem statement, I mean, it's pretty clear what they were supposed to do. And we know
Is it the plaintiff's contention that Deloitte should have built this computer system, the Connect system, to be able to handle the number of unemployment cases in Florida since approximately mid-March till now?
Yeah. I don't hear about these problems from all the other states. Why is it that only Florida, with their contract with Deloitte, couldn't seem to create a system that can handle the influx?
And
I
Judge,
mean,
let me
could-
add
could
something.
it-
At that
I'm
point,
sorry.
Ms. Maddox?
Florida, there's been some schematics that have been done in the New York Times, and they've gone through and showed that Florida is at the last, and I think we're tied with South Dakota or Wyoming or some states that only have a handful of claims. We're tied at last in terms of the processing of the claims.
But my question is that the fault of the computer company, or is that the fault of the state people operating the system?
We claim that it's both.
Mr. Kitchen is giving me the sign line. I don't know what this means. So maybe I scored a touchdown, Mr. Kitchen.
It's both, Judge. It is the failure to maintain the system, but it was created as a problem to begin with. And you know, you were talking a minute ago with Mr. Barron about the 5-lane road versus a path where you can't even drive a car. It's like a bridge collapses. And it's 5 years later that the bridge collapses. And what we have here is we have a total system failure at the time that it's needed the most. And so that goes back to Deloitte. The statute of limitations doesn't run on that. That's when the system needs.
Why doesn't it?
Because your damages aren't felt until now. It's just like a bridge collapse.
So if we have if the state just keeps the same system and in 15 years, we have another pandemic that's twice as bad as this, Deloitte gets sued for that?
I'm not sure about that. I'm not going to hypothesize that it's going to be the same system. Hopefully by that time they would have.
Hopefully you'll still be around to do the suing, Ms. Maddox, if that does happen. But
I promise you I will be. I promise.
Okay.
Judge, I want to answer that one though, because I would say,
Okay,
Deloitte,
Mr. Barron?
I would say Deloitte can't get sued at that point in time, because remember, the whole rationale behind statute of limitations is so people don't sit on their rights, so claims don't get stale. Obviously, if there was already this current situation, now the people are on notice of the issues that are going on with the system. They're not going to be able to go ahead and make the same claims, 15 years later. But I would say that there's no allegations at all that anybody's slept on their rights in this particular situation, or that any unemployed, who's sorry, Judge, go ahead.
No, I was just coughing. That's okay.
Oh, sorry. Yeah, there's no
Dry
indication.
cough, no fever, Mr. Barron.
That's okay. We're socially distancing right now.
Okay.
Yeah, there's no allegation at all that anybody's slept on their rights and failed to assert claims when they were aware of them. And that's the rationale behind the statute of limitations. And like I said, normally there'd be at least nominal damages for a lot of breach cases. In this case, there were no damages at all to the plaintiffs until this whole situation went down. The other thing too that counsel doesn't address, that is in our response to the motion to dismiss, that I think your honor should be aware of too, is that even if you believe that there might be a statute of limitations issue with regard to the third party beneficiary contract claims, we also provided some case law relating to the doctrine of equitable tolling of statute of limitations, which we think.
Yeah. Did you give me some cases on that? Because I'm the only time I see that is like, I'll give you an example, when somebody hides something that you couldn't have discovered the defect because it's been hidden or something of that nature, or there's been a misrepresentation made or something of that.
Yeah, I mean, this is not, well, I mean, I think you're talking more of like almost like a discovery doctrine type of argument. And I'm arguing under the cases we cited to, in particular, there's a Florida Supreme Court case called Matchley's at 523 Southern 2nd 1132. It basically says that the tolling doctrine can be used in the interests of justice to accommodate both a defendant's right not to be called upon to defend a stale claim and a plaintiff's right to assert a meritorious claim when equitable circumstances have prevented a timely filing. So, I mean,
Do you think the first district would affirm me if I decided not to enforce statutes of limitations because I felt in the interest of justice they shouldn't be enforced? There's got to be a rule on that, because I have a feeling I'd be reversed pretty quick on that.
I understand, Judge, but look, the equitable tolling doctrine says what it says. I mean, this is a very unique situation where, bit
I
more
will
ba-
read more on that. I will read it and read your cases on that.
Right. But I mean, again, we raised that as a backup position because I don't think that the statute of limitations applies here either anyway, when there's been no breach to the plaintiffs and not even nominal damages to the plaintiffs until approximately March of 2020 when the claims were brought. But I think that equitable tolling may be a fallback position also for the court. I mean, again, I understand, yes, if it was a clear-cut statute of limitations issue, I agree. You're going to get reversed if you don't follow the statute of limitations. But I don't think this is a clear-cut statute of limitations issue. This is, again, a very unique factual circumstance that we're not going to find any precedent on, in my opinion.
I tend to agree. There's multiple aspects of this case that are probably unique and new, but so let me ask you or Ms. Maddox, either one. I think what I've been hearing from Ms. Maddox is if I do decide to grant any dismissals, that she would like an opportunity to amend the complaint. Do you agree with that?
We definitely.
On the Deloitte stuff? I know Ms. Maddox is suggesting that she feels like she has further information she could amend to affect some of those arguments made by the state in their case.
Well, I mean, Judge, yeah, I know that Ms. Maddox may want to allege certain things, but I mean, with regard to, I mean, obviously, it depends on how you rule on some of these issues. You know, if you feel like, for instance, I have to set forth specific line, page, and section of the contract, then I'm going to obviously ask for leave to amend and not say it's futile and just dismiss me with prejudice, which would be the other option, right?
Well, here's the thing, and I think one of these cases, I've read so many cases on these motions this weekend and last week that I can't tell you exactly where it is, but it's here somewhere.
At least
And I'm just glad you can't see all my office on the camera instead of just part of it, but I do know as a general concept that dismissing a complaint with prejudice on the first motion to dismiss is usually frowned upon by the appellate court unless it would be futile to amend. And there's so many issues here, I'm not sure I can say that one way or the other now. So I do think that regardless of who wins or who prevails, at least on the sovereign immunity issues, I think those issues will go up to the appellate court on an interlocutory appeal. So, but if I move, I don't know if Mr. Norby's still there. Oh, there he is. Mr. Norby, I have a procedure. For some reason, I've decided you're the appellate expert today. So
I'll do my best.
All right. If I granted a motion to dismiss on an appellate issue, I'm sorry, if I granted a motion to dismiss on a sovereign immunity issue or a partial sovereign immunity issue, but gave leave to amend, would that be immediately appealable by by either side, the plaintiff? Let's say in this case, it'd be the plaintiff, I guess.
Yeah, Judge, if you granted a motion to dismiss with leave to amend, I'd have to look at that. It would be the plaintiff, presumably, that would be appealing that. I'd have to look at whether the defendants would have a right to appeal it to the extent it provides an opportunity to amend. So I think that would be the only basis on which the defendants would appeal an order granting a motion to dismiss would be the opportunity to amend. I did appreciate Mr. Boudet's comments earlier that if there is a basis to dismiss the complaint going to the court's subject matter jurisdiction, that would be a more appropriate way to dismiss a complaint than than some of the other ways that may require an opportunity to amend, such as the duty allegations and so forth.
Let me ask this question. If I grant a part of the motion to dismiss and deny a part of the motion to dismiss, that would give you, would that give the state the right to appeal that issue?
Yeah, Judge, if the court granted them, are you in your question,
Let
are
me
you
give you an
saying?
example. Let's say I granted it as to the purchase of the system and denied it, granted sovereign immunity as to the purchase of the system and denied it as to maintenance of the system. The state would have a right to appeal the part I denied, wouldn't they? On an interlocutory appeal.
I'm not sure about that, Judge. I think it would have to be granted or denied as to the specific claims set forth in the second amended complaint. Granted or denied as to negligence, granted or denied as to breach of fiduciary duty. I don't think that it could be done in the manner of a partial summary judgment where some aspects of the allegations are resolved. I think the motion to dismiss would need to address it claim by claim. That's my sense as I stand here.
All right, well, Ms. Maddox, you have one person who thinks you're highly intelligent. Apparently I clicked on the message thing and I read the message, so I thought you should at least get that compliment.
Thank you.
I don't know how to delete them, but that's fine. But so here's my dilemma. I don't think either side wants this case to drag on. But even if I were to be inclined to grant some motions to this parts or all motions to dismiss, then I would have to look real hard at a right to amend because of the laws I've said. If I grant with prejudice and don't leave a right to amend, then the appellate court might decide, well, I jumped the gun and reverse me on that procedural ground and not address the substantive issue. I feel like all parties want the substantive issues addressed as quickly as possible by an appellate court. So do you all have any thoughts on that? Ms. Maddox?
Your Honor,
Mr.
if I may,
Boudet.
I think that there are some issues that for which no amendment could cure the deficiency. At least with respect to Deloitte, let me, for example, on the question of sovereign immunity, Deloitte's sovereign immunity, the contract is in the record. The contract that Mr. Behrens candidly conceded he hadn't quite read before filing this lawsuit for breach of contract has specific provisions which are cited at page 7 of our reply brief that specify that the work being done by Deloitte is being done under the control of the state. We've pointed out 4 specific contractual provisions that, for example, establish an organizational structure with the state employees at the top making the decisions. We've identified the mandates for the state to approve what are called interim gate reviews. That is, at every stage of the progress.
I understand what you're saying. I'm going to have to do some more reading on that.
Yes.
Because if that were true, all the state had to do was put that in every contract they enter into, and nobody could ever get sued for their negligence.
Well,
or they'd have.
I'm not sure. I don't know. I think that the suggestion has been made could decide that as a matter of law, and no amendment could cure it.
What if the contract's ambiguous?
Suppose if the contract is ambiguous, but that hasn't been alleged.
No, but y'all want me to read it, and if I don't understand it, isn't that one sign of ambiguity? Or, well, it could be a sign of something else, but,
I suppose it could be, Your Honor, but we think that the contract is clear. We think that the state's acceptance, one of the issues here, for example, for the statute of limitations, a third-party beneficiary stands in the shoes of the contracting party. It can't have more rights than the contracting party does. So the state was certainly aware of whatever alleged defects were in the Connect system back when it was installed. When these IG audits came out in 2013 and 2014, those are matters of public record. So the statute clearly began to run on the breach of contract claim, and so no amendment could cure that. No amendment can cure the fact that the product liability claims are barred by the economic loss rule. No amendment can cure the fact that the negligence claim lacks a duty to protect another from purely economic harm. And no amendment can cure the allegation of a fiduciary relationship between these plaintiffs and Deloitte, and frankly, DEO.
okay, so let me get, because we're past time, but I want to give Ms. Maddox a chance to respond to my inquiry about that, those
Okay.
issues, appellate issues.
We-
Do you want to get up to the DCA quick, or do you want to drag it out? I guess that's my question.
Judge, we want an opportunity to amend because a lot of the claims that Mr. Boudet just made and said that we can't correct by amendment, we absolutely can. And more
Yes.
importantly, on a lot of, for example, the state contracting away its rights, okay, or the rights of somebody like us to come and sue and say, well, we'll just protect them under a contract, is analogous to a sheriff's office where you have medical providers, and the sheriff, by contracting with a medical provider in its jail, does not absolve itself of liability. And so that exactly the same thing here. So even though Mr. Boudet is arguing that, okay, it's just simply not true. So
What are your thoughts on the state's arguments? Are those also, do you have the same response as to their arguments as far as amending?
I do, and I think though that what we might do in light of the conversation today, and it's helpful to hear the court's views on things, we may come back and we may replete it differently so that we may only have, one area of argument rather than having 3 or 4. So it could be that an amended complaint eliminates some of their arguments, which I would presume that we would do when we come back in light of what the court has said.
Let me ask Mr. Norby for his thoughts on that.
Judge, I echo Mr. Boudet's thoughts. I believe that many of the deficiencies that we have identified and that Deloitte has identified in the second amended complaint are not the sort of defects that can be cured by creative repleting. The separation of powers issues are what they are. The lack of any fiduciary relationship between the department and untold numbers of individual Floridians, that is what it is. And an opportunity to amend would not cure those defects. We agree with the court's comments that everyone would benefit from getting this case into an appellate court at the earliest opportunity. I've not heard of any specific allegations of what would be asserted in a third amended complaint other than just throwing additional facts in or alleged facts about particular people's circumstances that don't really seem to get past the separation of powers concerns that we've identified or the sovereign immunity concerns that we've identified. The nature of the duty that is being asserted in the complaint as against the department is a matter that is an issue of law that's for the court to determine based on everything that's been set out in front of it. And additional factual allegations about plaintiffs doesn't do anything to one way or another on whether the department had a duty enforceable in tort to individual plaintiffs under this system. That's a matter of common law and statute, and that simply is what it is, Judge.
Okay, thanks.
Judge, can I just add one additional thing?
Yes, Mr. Barron.
Or you can interrupt me if you think if I'm stepping on any toes here, but it's really my contention, though, that regardless of whatever you do with regard to the states, the rulings as far as the sovereign immunity issues go with the state, that we, other than whatever we may amend, that we should be entitled to proceed against Deloitte with all of our claims. Deloitte is not equal to the state. Deloitte may want to say they're equal to the state, but they're not. And I don't think the state's going to want to say they're equal to Deloitte. So,
well, I understand what you're saying. Setting aside the issue of sovereign immunity, because I want to look at that again. That's an area, the sovereign immunity of Deloitte. That's an area I'm familiar with, but not as much so as I am in other areas. But you set that aside, and Deloitte and the state have some similar considerations, but in other ways they're different in that Deloitte's private and the state's a public entity. Now, Deloitte may have, if they're correct on their sovereign immunity argument, that would be different, but I don't have a decision on that yet. There's some things I have points of view on, but there are many more that I do not have any well-formed conclusion on. I want to go through and read everything again. It's not the most complex complaint Ms. Maddox has ever written, but it's not the most simple one she's ever written either. And I want to give everything its just due in the arguments of all the parties. I'd like to be able to do it today, but I'm just not sure that would be a fair thing for me to do, because there's so many issues and they seem to be sort of interlocking. And I think what I'm going to do is, once I've decided what to do, I will send you all. Probably I'll do it in the form of a pleading, since this is a case of high interest that says, here's my rulings. These are my conclusions and the rulings, and I want you all to draft an order consistent with this. I won't draft an order, because if I have to draft an order, it will take an extraordinarily long time for me to do that, because as of in about 8 days from now, my caseload is anticipated to go up from 824 to 1,000 or over. So when we're readjusting some things in the assignments, we're reducing a half a load of civil and dividing it among the ones left. So, and I'm not complaining, I'm just saying that in writing a detailed order like this, for me to do it, because I don't have an associate, I don't have any partners, and I don't have any clerks who could write it for me. It just takes too much time for me to do that and drop everything else. So, but I will try as soon as I can. I have filed right before this hearing started. I had someone file an emergency motion for a hearing tomorrow, which I set for tomorrow at 10. So it's a process, and this is important to all of you. It's important to me to get past this stage of the case and get some decisions made. Whether I have a feeling not everyone's going to agree with every decision I make, but I can tell you I'm not sure what decisions I'm going to make on many of these points at this point, because I want to take what you said. I want to read your briefing papers again. I want to read these cases again, and I can't wait, Mr. Barron, to get into the contract. And so I will be reading that too, since it's now part of the complaint. So do y'all have anything?
The only thing I would add, Your Honor, is after you go through this next review, if there's an issue or other issues that you would like additional briefing on, of course, we're happy to provide the court anything else you'd like us to.
I'll do that, and if I need something from you all, I would probably just send an order giving all parties the right to do it. I think everyone's done a good job at briefing. They've done a good job at citing cases. And to be honest with you, there are just some areas that I have a feeling have never been decided before. Some of these principles of law are not new, but applying it to a case with these facts is a little bit on the new side, or at least it's complicated. So I need to go through the complaint again, and I'll let you know as soon as I get something. And I want to try to do it as quick as I can, but I have, my whole office is full of court files and parts of court files with other people who are waiting for me to decide their case too. And I'm trying to do it as fast as I can. I worked this weekend, both days on this case to try to get where I am. And I feel like I still have more time I need to put in on it. So.
Judge, would you indulge us for 1 minute? Mr. Kitchen, there may be something that I've missed. And if
Okay, did he want to raise a point? I'd be glad to hear him.
could we have 2 minutes? And it's not really, it's just, yes, if there's anything else that he can add.
You want 2 minutes to talk to him, or you want to put him on the speakerphone again? Either way is fine.
You want to add? I put him on. There we go.
Okay, Mr. Kitchen, go ahead.
I know that this is,
You're gonna have to step out of the room again, I think, because the court reporter can't hear you.
Judge, forgive me for not being on camera.
That's okay.
But the things I just wanted to address, and I apologize, I've literally been mute during this hearing.
That's all right. I understand technology.
You know, it was said by the ancient Greeks that success has 1,000 fathers, and failure is an orphan. I've witnessed that today. And I think that the person that commented on Miss Maddox being brilliant is absolutely right. And that's why I wouldn't do this case with anyone other than her. I think, Ron, and I'm comfortable saying, remembers an old guy named Cliff Davis out of Monticello that used to try cases in the Second Judicial Circuit. And he always said in dog bite cases, his first defense was you weren't bit by a dog. His second defense was if you were bit by a dog, it wasn't my dog. And his third defense was if you were bit by my dog, I don't have a dog. That's what I'm hearing today.
Well,
Is being passed more than a football by Dan Marino, and I understand the legal arguments. I get all of it, but basically what they're saying is it's not our fault, and if it is our fault, we can't be held accountable. The legal arguments may be coarsely sound, but to go to the traffic light deal, show me the traffic light that's down 70% of the time and they're not liable for it. Show me the traffic light that is down 70% of the time and the numerous prior accidents that never made the paper and never made the news were not remedied or mitigated in any way. That's what we're dealing with here. The analogies simply don't.
I'm sorry, simply what? The analogy is simply what? I didn't hear the word.
I didn't hear it either. They don't something.
You said, Gosper, that the analogy simply don't fit.
Did he say that dog don't hunt?
Yes.
Or fit? Okay.
You can say it that way,
All
too.
right.
We'll get that in a little while. That dog don't hunt either.
All right.
There's no remediation or mitigation until after people in a week's time got killed at that traffic light, got slammed at that traffic light. All of these analogies are not proper. And you know, Your Honor said it, that these are things that we have not necessarily visited before. And that's okay. That's why we have stare decisis. That's why we have case law. But to say that in the wake of this absolute disaster, that no one can be held accountable, not Deloitte, not the government, The government and Deloitte right now are in bed. I'll bet you, Judge, 6 months from now, they're going to be pointing fingers at each other. And I don't care. Put them in a circle. This isn't an either or. This is a yes and. You brought
Well,
up-
there are different ways to hold people accountable in multiple different ways, so I can't speak on those. All I have is what's in front of me now, and I'll do the best I can to get it right. And I know the district court will, the district court is going to review whatever I do, and I kind of wish they were sitting in here with me. There could be 4 of us sitting here, so. It's a complicated task, but it's part of what I'm tasked to do. And the lawyers have all done a great job in assisting in that regard. The court reporter has been very excellent in taking down everything we're saying. And unless there's anything else y'all want to say, I'm good. Ms. Maddox, do you want to talk with Mr. Kitchen?
We'll rest on our brief.
Okay, anything else that anyone would like to say?
Thank you, Judge.
Thank you,
All
Your
right,
Honor.
good luck.
Very much. And Judge,
I
thank
feel
you.
for some reason like this is a Friday, but I know it's not. So you all have a good rest of the week.
Thank you, Judge.
Judge.
Okay. All right. Goodbye. We're off the record now.